May it please your lordship, my lord.
What is this?
May it please your lordship, my lord.
Promotion to the post of process server in MSP Nogam. The Gauhati High Court has filed their affidavit 4 days ago. But I've been instructed to file a reply against the government. Okay, we'll see when the matter is.
May it please your lordship. May it please your lordship, my lord.
Limited interim order that day. Have you got it? If it has not been issued, then to not be issued, but if it has been issued, subject to outcomes. Wait from.
May it please your lordship, my lord.
Lordship, I'd like to mention item number 28 and 29. Lordship, in this case, we were directed to file an affidavit by 10th of June, and we have filed it yesterday, Lordship. But today, I have some personal difficulties, Lordship. Can it be taken up in the week commencing from 22nd or after vacation, as per your Lordship convenience and my Internet friends council? See, this case, the details will be very sad.
Just listed once before vacation. Can be listed just once before the vacation.
Okay, we'll have it. This is a review matter. It will come before me only.
May it please your lordship, my lord.
Yes,
Am I audible to your lordship?
very much.
My lord, I'm stuck up in Jorhat in a very extraordinary circumstance. I came yesterday for appearing in a matter in Jorhat. In the afternoon, my driver got, my lord, badly ill, my lord. So I cannot move out, leaving him alone here in Jorhat. So I'm stuck up, my lord. I have two matters in your lordship's court at item 17 and 19, my lord. If lordship pleases, my lord, can it be taken up?
Wait, Mr. Somo. Let me deal with this item number 28 and 29 first.
Well, as your lordship.
Let me first deal with it. Let's have it on 16th of July.
Well, as your lordship, 17 and
No,
19.
not your matter.
Oh, sorry.
This is 28 and 29. You are not there.
My lord. I'm in 17 and I'm in 17 and 19.
Request of Mr. P. Bolwa, the learned counsel for the ONGC. The matter stands adjourned to be listed on 16th of July 2026. Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner, expresses urgency on account of there being no interim order. Under such circumstances, there shall be no further adjournment on the next date. Yes, Mr. Zumbo.
My lord, I was explaining to your lordship, my lord.
You are referring to item number?
17 and 19, my lord. My lord, very extraordinary circumstance. I cannot leave my
18.
19, my lord.
Huh? Item number?
17 and 19. Hiranya Hazarika and Lokshinath Das.
You are paying for?
In Lokshinath Das, I am respondent, and in Hiranya Hazarika, I am the petitioner.
17 to petitioner 1, 2 respond number 4. Huh? At the request of Mr. A. Somewhat, the learned counsel appearing on behalf of the petitioner, the 17th. Very good for a respondent. The matter stands adjourned to be listed again on 23rd of July 2026.
I'm deeply obliged. I'm deeply obliged.
Who had expired?
Management of
Is the matter pertaining to? Matter pertaining to? Liver award. We are not concerned with it. Huh? Is the management there or not?
Management is there, actually it is informed by the son of the 1 week back, it expired.
We'll see when the matter reaches. Not now. Okay. Said, I, one of the last written window, submitted that the when is attained the age of superannuation. And he is not attained the superannuation. He will be retiring on 1st of March 2029. Here, only the question is whether the respondent number one would be entitled to the back wages. My lord, he has not attained the age of superannuation. He is retiring on 1st of March 29. Now, my lord, yes, that means it. Now, somebody made the submission, respond number one, last time when the matter was taken up, that in the meantime, the respond number had crossed the age of superannuation.
The date of retirement is 28 to 29
Okay.
as per record.
Let them get the 73 minutes. So then we take it up the matter. Tell me, what is your case? Are you are challenging an award. What? You don't have urgency.
SN Tamul is out of this station. Mr. SN Tamul is out of the station.
So what? How does it matter? The whole matter, this is a award of a person have.
Misappropriation of 85,550. This was not located.
You got some money. You got some amount.
See, admission again. Admission again.
There's a finding, if I remember, I have seen this matter earlier. Ah, here is the case. There was no misappropriation. 88,500. Then I got the place. My yes is too much.
Another allegation is located. Suited one into us.
Hello, yeah, can I place my case? No case. I place. Ask. I've got place. Can I place my case? Yes. Ali, well, in this case, my lord, the workman was dismissed after holding a domestic inquiry. Yeah, but to one how it goes. In this case, my lord, the workman was dismissed after holding a domestic inquiry. In
Wherein when the domestic inquiry is held against the workman before the dismissal the management, if the management wants to relay the domestic inquiry in the tribunal has to first consider the domestic inquiry. Here in this case, there is no whisper about the domestic inquiry. Here is the inquiry's purpose. The learned tribunal has not dealt with the inquiry, domestic inquiry matter. It directly proceeded with the case on merit matter. In this case, I want to place a judgment of the Honorable Supreme Court matter. Okay, the citation is 1972, 1 SCC, page 595. In domestic inquiry, the charges proof matter. Yes. Any family member, they can consider
First and foremost, you put a plea in your written statement.
Yes.
About that. Then the award was fast expected.
First expertise.
Matter gets remanded back to the tribunal. After it has been remanded back to the tribunal, you started accusing evidence of everybody.
It's simultaneously dismissed.
No, you started evidence of everybody.
Not made.
Yes, you gave the evidence of all the management witnesses.
We have evidence of inquiry itself and other two witnesses on merit.
Other two also have given on merits.
Yes, madam.
Then who is the management witness number one?
He is the manager, madam. Deputy
So
manager.
therefore, he has against the evidence.
Yes.
So on merits, you have against the evidence.
We have simultaneously dismissed.
What simultaneously?
Is a domestic inquiry in support of domestic inquiry as well as on merit.
Have you read your written statement?
Yes, madam.
What do you say?
Lordship, we
You
have taken.
categorically say
We have
in
taken
particular paragraph. Categorically say in this paragraph. The management further begs to submit that they would rely on the domestic inquiry held by the management first. And if the learned court holds that the domestic AI is not in order and violating on the threat, they intend to lead evidence to prove their case. So therefore, why did you adduce evidence on merits?
Malad, as part of judgment, malad, I have cited malad.
Forget about the judgment.
And we can deduce evidence in support of domestic inquiry as well as
No,
on merit.
Mr. Counsel, you cannot come up with this judgment here after a passage of from 2014 to get this matter remanded back. Sorry.
Malad, was malad, initially it was ex parte, malad, next remanded back, malad, then they appeared. Second.
You have only conceded that aspect before the learned court net bench when the matter was taken up. Have you seen the judgment of yours?
I have seen.
Kindly see
That was
page 55.
Merit. It was
No, kindly see page 55. Thereafter, did your lawyer ever raise that, look here, first take care of the issue of domestic inquiry? No. When the issues have been, draft issues have been given, opportunities were given to both the sides. You never said that, okay, preliminary issue may be framed on this aspect. You never said. You took all this time, and now would it look fair on the part of this court in the year of an act which happened in 2004 to remand it in the year 2026? I think the division bench may help you out, not me, on this issue. Whatever the Supreme Court has said in 1971, it is good, but that has to be on the basis of those facts. Yes, it was your duty to raise it. If you see the Constitution bench judgment, I think that is the case pertaining to where a leave was required to be taken at the time of when the domestic inquiry which is relied upon. Constitution bench said that there is an urgent necessity that a matter should be disposed of within a period of 6 months. Now we are looking into a case which is 22 years old. And these are findings of facts. Why should we interfere?
Still, my lord, the landed tribunal has the duty to go
Sorry,
to the domestic inquiry.
let me pass the judgment now.
My lord, in the domestic inquiry, my lord, charges have been put.
Sorry. You never raised that. You never argued that. You went on giving all your evidence. And doing all this while, everything happened. Now can you raise that? And the labor court has also looked into it, that the domestic inquiry is not there. What other evidence are you going to give? Tell me. You have adduced all your, you see, you are saying about a prejudice. Now the question is, have you seen the evidence of a management witness number one?
Yes.
He has given it on merits. He has given on merits everything. Number two has given on merits. It is management witness number 3, who is the inquiry officer who came over. So then, okay. Now, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. So-and-so, who appears on behalf of the respondent. number 1. The present petition has been filed assailing the award dated 21/2025 passed in reference case number 4/2012 by the learned presiding officer Industrial Tribunal at Dibrugarh, whereby the learned Industrial Tribunal had passed an award thereby holding that the termination of the dismissal of the petitioner of the workman, namely Sri Keshav Bora, was not justified, and directions were issued that the workman be reinstated to his service with full back wages from the date of his dismissal. Before dealing with the facts, this court finds it very pertinent to observe that when the instant petition was taken up by this court on 22/5/2026, a submission was made by the learned counsel appearing on behalf of the respondent number 1 to that effect that the respondent number 1 had crossed the age of superannuation. Today, it is being mentioned that the said submission was made without concurring with the workman and also without taking note of the facts. It is also relevant to observe that based on the said submission which was made on 22/5/2026, this court opined that the only issue in the present proceedings was as to whether the respondent number 1 would be entitled to back wages. But however, taking into account the facts, materials on record, as the respondent number 1, that is the workman, would have retired on
28/2/2020.
28/2/2029, both the issues involved in the instant proceedings are present. The issue pertaining to reinstatement with back wages is required to be adjudicated. Next, facts. On 27/10/2007, the workman, namely Sri Keshav Bora, hereinafter referred to as the workman, was issued a charge sheet alleging inter alia that the workmen, with the intention of personal gains, entered haziras, bracket, named in the master room of 22 labor, 22 temporary Horijan women, 22 workmen temporary workmen Footstool. It was also alleged that though the workmen tried to, tried to make payment to those temporary workmen, but was not successful. It was further alleged that on 2nd of October 2007 at 1:40 p.m., the workmen created an unruly scene in the garden assistant manager's office when the workmen kicked the permanent worker Sri Mintu Das to vent his frustration. It was also alleged that the workmen entered the deputy manager's office at 2:15 p.m. and wanted to know when the unpaid balance of bonus payment would be made. In that process, it was also alleged that the workmen had broken a glass pen in the office of the head clerk and shouted unparliamentary words. It was therefore alleged that on further scrutiny of records, it revealed that for a period from 24/3/2007 to 5/10/2007, the workmen had authorized payment for a set of temporary workers even though they were not actually working, thus causing loss to the company in terms with financial payment of rupees 88,550. The workmen, upon receipt of the said Shoka's charge sheet, Shoka's notice, dated 24/10/2007, replied denying to all allegations made in the said Shoka's notice. Upon receiving the said reply from the workmen, the manager of the petitioner estate being not satisfied, initiated an inquiry, domestic inquiry. The inquiry report was submitted on 8/2/2008, holding in the alia that the workmen had committed acts of fraud, theft, and dishonesty with the company's business. It was also alleged, also opined in the inquiry report that the workmen had committed the acts of willful disobedience, abuse, and threat to the superior officers, owners, and also were guilty of acts of quarreling, fighting, and causing disturbance, prejudicial to good order, and repeated negligence on his work which amounted to gross misconduct as per the standing orders imposed in the state. The said inquiry report was furnished to the workmen by the communication dated 15/3/2008, and the workman replied on 19/3/2008. Categorically stating that the domestic inquiry was conducted in a biased manner and the workman was not granted an adequate opportunity to defend himself in a legal manner. It was also mentioned that the workman was deprived of preparing any defense inasmuch as the list of witnesses was not furnished to the workman. In addition to that, the workman in the reply can also mention that the allegations that the workman had assaulted a co-worker was absolutely false, and that the workman had submitted an apology letter was also false. Next. In pursuance to the said reply, the petitioner, the management of the petitioner estate, having not found the reply to be to their satisfaction, terminated, dismissed the petitioner. With effect from 25/3/2008. Next. In view of the dismissal, an industrial dispute arose for which the government of Assam, by the notification, referred the dispute for a decision to the Learned Industrial Tribunal, Dibrugarh, with the following terms of reference. Number one, whether the management of Bedjan Tea Estate are justified in dismissing the services of Sri Kesop Bora, Mohara of Bedjan Estate, Uchunma. Number two, if not, whether the said workman Sri Kesop Bora is entitled to reinstatement with full back wages or any other relief in lieu thereof. Pursuant to the receipt of the said reference, the notification thereby referring the dispute to the Learned Industrial Tribunal, Dibrugarh, a reference case was initiated, being reference case number 4/2012. The records reveal that though notices were issued, only the management appeared and filed the written statement on 19/3/2013. It is very relevant to take note of that at paragraph number 21 of the written statement filed by the management, it was categorically mentioned that the management intended to rely on the domestic inquiry first, and if the learned court hold that the domestic inquiry is not in order and violative of the principles of natural justice, they intend to lead evidence to prove their case. The records further reveal that on behalf of the management, one witness was examined. The records further reveal that the reference proceedings proceeded ex parte against the workman, as the workman did not put in his appearance. Be it as it may, on behalf of the management, one witness was examined and discharged by an order dated 4/5/2013. Subsequent thereto, on 27/5/2013, an ex parte award was passed. The workmen thereupon put to challenge the said award before this court by filing a writ petition, which was registered and numbered as WPC number 1686/2018. The learned coordinate bench of this court by an order dated 15/12/2022 upon their consent set aside the award dated 27/5/2013 and remanded back to the tribunal for fresh consideration. Paragraph 12, 13, and 14 of the said order passed by the order dated 15/12/2022 being relevant is reproduced hereinunder. The record further reveals that on 11/4/2023, the written statement was filed on behalf of the workman. could also be seen from the reports that initially, on behalf of the petitioner, there was no appearance till 21/6/2023, when an application was filed on behalf of the petitioner for allowing them to adduce further evidences, including the evidence of the inquiry officer, Ms. Aruti Sharma, which was allowed. The records further revealed that on 5/7/2023, 1/8/2023, 7/8/2023, 1/8/2023, the reports further revealed that on that on 1/8/2023, evidence of 3 more witnesses evidence on the affidavit of 3 more witnesses were filed by the management. The witnesses thereupon were cross-examined. And thereupon, the records do not show at any point of time after the remand being made by this court by the order dated 15/10/2022 that the petitioner side ever asserted that the petitioner would like the court tribunal to first adjudicate on the issue pertaining to the fairness of the disciplinary inquiry, of the domestic inquiry. Rather, the petitioner continued with adducing evidence on merits. The respondent, the workman side also adduced various witnesses on merits. also very pertinent to mention that on 2/5/2023, the learned presiding officer had formulated the issues, 3 issues. Which included the issue of, which included the formulated 3 issues, which are hereinafter. The above issues which should be seen were neither objected by the management at any point of time, but rather the management proceeded with adducing evidence in terms of the said issues which have been framed. The learned Industrial Tribunal, by the impugned award dated 21/2025, after taking into account the evidence on record, came to a clear finding that the dismissal of the workman was not justified, and as such directed reinstatement with full back wages. It is under such circumstances the present proceeding was filed. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submitted that the learned labor court, an industrial tribunal, committed a grave error in deciding the fairness of the domestic inquiry as well as on merits. Without first deciding the domestic inquiry, which is the requirement of law in view of the judgment of the Supreme Court in the case of Delhi Cloth and General Mills versus Luput Singh, reported in 1972, 1 SEC 595. And in that regard, refer to paragraph 61, Roman 3, Roman 2 and Roman 3. 61, Roman 2 and Roman 3. Refer to paragraphs 2 and 3 of paragraph 61. Isn't it? 2 and 3? Oh, no, both is not available. Only 3. Refer to paragraph 3 of section of paragraph 3 of the section. Anything more on marriage? Marriage, you don't have a case. All your witnesses have gone against you. What? Regarding the standard of proof. Standard of proof. It was decided like a criminal case by the land traveling. So standard of proof is different. The domestic and no, your main problem first, you have a problem. 88,000 have not been misappropriated. That was approved. That amount has been said by the management witness number 1 as well as management witness number 3. They have categories. As regards uh, uh, hitting Mintu Das or Mintu whatever way, he gave evidence on the other hand before the tribunal. The domestic inquiry, he has given evidence. He has also understood, but you see that evidence is different. My question is, he gave evidence before AR that he was never hit. Then the person concerned, the head clerk of that, who gave evidence before the tribunal, that person who came out, he never said anything whether who was that person who broke the pain. That's your evidence. They're saying their person. Understood, but that is the evidence then. So you could not prove it. But first, my lord, we have to consider the domestic inquiry. My lord, that is okay. Domestic inquiry, I'll deal with that. But the second is as regards the perversity. So your argument will be on perversity. Perversity also many times happening 2 more judgment, my lord. What? Regarding my lord, the learned tribunal cannot change their findings of the domestic inquiry. What? The learned tribunal cannot replace the findings of the domestic. Show me. 2006. I've never heard such judgments. Anyway, you keep on doing. Let me the Mr. So-and-so, the learned counsel appearing on behalf of the petitioner further submitted that the findings of fact arrived at by the learned tribunal is perverse in as much as the evidence which was adduced before the domestic inquiry was not taken into consideration. Once the dossier has based on evidence comes to a particular conclusion, normally it is not open to the tribunal and the court to substitute their one is right. Paragraph 20. Yes. In that regard, he has referred to the judgment of the Supreme Court in the case of divisional controller NEARTC versus K. Amarish, reported in 2026, 2006, 6 SCC 187, and more particularly referred to paragraph number 20. Anything more?
Regarding this standard of proof, standard of proof.
In addition to that, the learned counsel also referred to the judgment of the Supreme Court in the case of Cholan Roadways versus G. reported in 2005, PSCC 241, and submitted which paragraph? That submitted that the tribunal, while exercising its jurisdiction under the Industrial Disputes Act, was required to bear in mind that the standard of proof required in a domestic inquiry vis-a-vis a criminal trial is absolutely different. The standard of proof which is required in a domestic inquiry or before the industrial tribunal was preponderance of probability and not proof beyond all reasonable doubt. By contrast, the learned counsel appearing on behalf of the respondent submitted that the proposition of law stated by the learned counsel appearing on behalf of the petitioner, that it is the requirement it is always necessary for the tribunal to first decide the validity of the domestic inquiry and thereupon can proceed on the merits. Cannot be a universal proposition. Even as per the judgment of the Supreme Court in the case of Ludbut Singh Supra, the learned counsel submitted that though such a plea was raised by the petitioner in his written statement, it was also the requirement of law that the petitioner followed the said wit before the tribunal. In that regard, the learned counsel referred to subparagraph 4 and 5 and 6 of paragraph 61 of the judgment in the case of Ludbut Singh, and further submitted that in the instant case, the issues were framed as on 2/5/2013. 23. The respondents, the petitioner herein continued to adduce evidence on merits and never raised the objection. The objection is being sought to be raised only in the instant proceedings. The learned counsel submitted that these objections are being raised now so that the proceedings get so delayed. Thereby, the petitioner, the workman, loses all hope in this industrial dispute adjudication. The learned counsel appearing on behalf of the respondent further submitted that the findings of a domestic inquiry, no doubt, has to be duly taken note of by the industrial tribunal. But if the domestic inquiry is biased, if the domestic inquiry is biased, and the findings are perverse, which is not supported by the witnesses or even of the management, it is always open to the industrial tribunal of the labor courts to substitute such findings of facts. The learned counsel further submitted that in the instant case it would be seen that the impugned award, in the impugned award, the learned industrial tribunal have duly taken note of each and every evidence and have precisely applying the law come to a finding that the charges of misappropriation as well as insubordination and assault would not be proved. The allegation which was made of misappropriation could not have stood ground, taking into account that it is the very admission on the part of the management witness number 1 and management witness number 3 that the money was never disbursed by the management. The learned counsel further submitted that the charge of assault against one Mintu Das was absolutely false, as would be available from the witness so given by the said person before the learned labor court as workman witness number 6. The learned counsel further submitted that the witness, the evidence of that the management witness number 4, who was the person on whose basis allegations were charges were leveled against the petitioner, that the workman was involved in an act of insubordination, also could not be proved, inasmuch as in his cross-examination he categorically mentioned that this particular person, he did not recognize who was the person. It is under such circumstances the learned counsel submitted that the findings of facts which have been arrived at by the learned tribunal calls for no interference in the proceedings under Article 2 to 6 of the Constitution, inasmuch as there is no perversity. Anything more?
Kindly page number 32, Lordship. There are list of they made list of witness that 22 women workers they have mentioned that 2-3 women they become the witness, but management not examined them, cross-examined them, Lordship. Then inquiry report, Lordship.
The learned counsel further submitted that in the allegations which were made that these workmen, the allegations which were made that the workmen had tried to make payment to some of these workmen, temporary workmen, was also falsified by the witness evidence of the workman witness number 2, 3, 4, 5. And the management refused to cross-examine these witnesses before the learned industrial tribunal. This court have duly heard the learned counsels appearing on behalf of the party and have perused the materials on report. In the previous segments of the instant judgment, this court have duly taken note of the manner in which the proceedings before the learned industrial tribunal were conducted. As stated above, initially, on account of the management witness, on account of the workmen being absent, an award was ex parte award was passed by the Learned Industrial Tribunal on 27/5/2013, and thereupon the same was remanded back by an order passed by this court on dated so and so in WPC number so and so, and the relevant paragraphs have already been quoted here in above. The records further reveal that on 11/4/2023, the workmen filed the evidence, filed the written statement. No reply thereagainst were filed by the workmen, by the management. On 2/5/2023, draft issues were submitted on behalf of the workmen. And these draft issues were thereupon, on 2/5/2023, the three issues were framed, which have been already quoted here in above. The management side thereupon appeared only on 21/6/2023. And prayed that they would like to adduce further witnesses. In the entire order sheet, as well as the various applications filed by the management, there is nothing on record to show that the management at any point of time requested the Learned Industrial Tribunal to first adjudicate the domestic inquiry and then to proceed with the adjudication on merits. In this regard, this court now finds it relevant to take note of paragraph number 61 of the judgment in the case of Ludbut Singh, which is reproduced here in under. in the opinion of this court, the observations made by the Supreme Court in the case of Dubgut Singh at subparagraph 3 of paragraph 61 cannot be taken in isolation. The said paragraph, the said proposition laid down in subparagraph 3 of paragraph 61 has to be conjunctly read with other subparagraphs of paragraph 61. Which imposes an obligation upon the management to request the tribunal to try the validity of the domestic inquiry as a preliminary issue and also ask for an opportunity to adduce evidence before the tribunal. Merely making a statement in the written statement and without pointing it out and without making a specific request to the tribunals that a preliminary issue be framed it is the opinion of this court that rendering a frame and thereupon leading evidence on merits. It is the opinion of this court that after the award being passed to raise such objection in a writ proceedings cannot be permissible under law. The court also duly takes note of insofar as the merits are concerned. Mrs. Yap, tell me one thing. Where is the finding as regards the domestic inquiry here in the impugn award? No, no finding. No finding.
Yes, recorded some statement of some witnesses, but there is no finding.
Where is the finding?
Start from is
41 look.
paragraph 11, Malak. Yeah, paragraph 11, finding started.
There's nothing.
There is no finding.
So issue number 1 has not been decided.
Yes, yes.
Let this court now take note of the merits. In the previous segments of this instant judgment, this court had duly taken note of what are the 3 issues which were framed on 2/5/2023. It included the issue pertaining to the domestic as regards the fairness of the domestic inquiry. Issue number 1 specifically dealt with the domestic inquiry conducted by the management, dealt with as to whether the domestic inquiry conducted by the management was justifiable and was conducted by following the rules of natural justice. However, the findings of facts, however, a perusal of the entire impugn award shows that there is not a single whisper as regards the decision pertaining to the fairness of the domestic inquiry, which was the issue number 1. And the learned tribunal went into the other 2 issues. In the opinion of this court, that the impugn award dated 21/2025 cannot be sustained in law without a decision in respect to the issue number 1. There's no further issue to be made, no more evidence to be given by anybody. Okay. Only to be decided on. This court inquired with the learned counsels appearing on behalf of the parties as to whether any further evidence is to be led in those proceedings. In the circumstance, the matter is to be remanded. Accordingly, this court sets aside the impugn award dated 21/2025 for the reason aforementioned. has to set aside the impugn award dated 21/2025. In as much as when the domestic inquiry is being relied upon, and there is also a requirement, an issue have also been framed as no decision is rendered as regards the validity of the domestic inquiry. The said impugn award cannot be sustained in law. Accordingly, the repetition stands disposed of with the following observations and directions. The impugn award dated 21/2025 passed in reference case number 4/2012 by the Learned Industrial Tribunal Dibrugarh is set aside in quash. Number two, the Learned Industrial Tribunal Dibrugarh is directed to decide afresh the said reference proceedings, taking into account that the learned counsel, the petitioner now have urged that the preliminary issue has to be taken as regards a preliminary issue be first the domestic inquiry. The fairness of the domestic inquiry is required to be first decided. This court directs the industrial tribunal to first decide on the legality and validity of the domestic inquiry report dated so and so. And thereupon, if necessary, decide if necessary, and thereupon, if the learned tribunal is of the opinion that the domestic inquiry was not fair and not conducted as per the rules, and this court direct the learned tribunal to first decide the issue number one. Next, based upon the decision of issue number one, the learned tribunal shall thereupon decide the issue number 2 and 3. It has been submitted at the bar that both the petitioner as well as the respondent would not be adducing any further evidence. And as such, on the basis of the evidence which is already available on record, the learned industrial tribunal shall do the needful as directed above. Taking into account that the respondent was dismissed from service in the year 2008, the learned industrial tribunal shall decide the said dispute within a period of 6 months from the date of appearance of both the parties before the learned tribunal. Both the learned tribunal, as both the parties are duly present before this court, they are directed to appear before the learned industrial tribunal on 13th of July 2026. The registry shall forthwith return the files along with so and so. You should have said that only.
Yes.
Why you are into loot-booting?
My lord, I have my submission was first submission was there.
And first, second is try to raise your voice in the court. Nobody can, that mic has no problem. You ask anybody else. I can hear everybody. This is your main point. That issue has not been framed. You even have not mentioned that these are the 3 issues.
I don't have that issue, my lord.
What?
Subsequent issue, my lord. I don't have that subsequent issues. And subsequent key issues, my lord, came, my lord.
See, I am not only saying, everybody is saying.
I have not got the key issues.
Now better.
Yes.
Yes. You have not got the records. Not necessary. The records are already there, na? You should, is it the duty of yours or me to look into the records? Is this the duty of you or me? The duty is yours.
Yes.
Are you not paid by your client to appear before the court? Or you are doing it pro bono? Pro bono. No. Then it is your responsibility to look into the file. And this is your main issue. These are the three issues which have been framed. The first issue have not been decided. The matter is there, finished. When I saw the judgment to look into it, where is the issue number 3? One, it is not. Otherwise, it is the case was in your head.
Certificate with the photographs of the earlier certificate. This was rejected by the
Where the rejection?
rejection is at page 155. Rejection is they are saying that you are using the photographs which was used earlier. But relating to the same site, and in relating to the same site, they have given certificate. PWD, rejection, they are saying on the page 155, with reference to the application, I have to inform you that the geotag location, GPS location photographs which is enclosed along with your application under reference is on 10/2/26. That is earlier, we took it. This site verification certificate with reference to the photograph dated so and so has already been issued from this office by so and so. I'm using the same photograph removed to the same site. And
Have you submitted your bill?
yes, submitted the bill, they have not opened it as yet. They have not opened it as yet, but I am apprehending because of non-issue of the earlier they have issued, your lordship, can you see page 88? Earlier certificate, earlier tender was 6/2/26, which was cancelled. On 16/2/26, that page 88, they have given the certificate. In relating to the same one. Only thing is that they cancelled it, they have retendered. And I have
Then you did not go for another site visit.
another site visit, sir. Well, that's same site, we have used the same photograph which was used earlier.
But you see, the problem is this. Kindly come to page 88.
58, yes.
This certificate is valid for this particular work package against the tender number.
Yes. This was
So
cancelled.
then why did you apply? To this?
This was cancelled. This certificate for the first tender was issued on 6/2/26. That your lordship will get it at page 22. This was for that relating to the same work. For that site verification certificate was given. That your lordship has in page 18. This tender was cancelled on 15/3/26. And they again retendered on 16/3/26 for the same work. Page 89.
Show me the first one.
First one is 6/2/26, page 20. Same work.
Yes, Mr. Das.
And only I would like to point out to your lordship that the PWD has given up this site visit certificate. Your lordship will kindly see what they have said, page 160.
Decided to remove that one and fresh tender was issued. Accordingly, the PTs convinced all the bidders who had participated in the fresh tender had submitted the site visit certificate of the fresh one, means new site visit certificate. But the petitioner had enclosed the site visit certificate of the earlier one.
Correct. Now I filed an application on 154, page 154, dated 18/3/26. They filed an application, then they have rejected on 25 earlier.
Lordship.
Certificate, we have filed an application for providing the site visit certificate.
Site
Page
visit
154.
certificate, they have, Lordship, what they have stated in their letter on 10/2/26, they have applied for the site visit certificate. Accordingly, site visit certificate was issued along with the photograph. But on 10/2/26, they have applied again for the site visit certificate with the old photograph, Lordship, which they have already annexed on 10/2/26.
page 100. I begin. That is require any new photograph.
This is a new tender option.
Understood. Here, you are asking for the photograph. Yes. Where the necessary that there has to be a photograph.
Since the earlier tender has
No,
already.
no.
Yes,
So
it's-
as per the new tender. Yes, where is the requirement for the photograph?
The details at their own responsibility and they have to visit the site and examine the site at the work. That site visit certificate will,
Where is the requirement for the photograph?
Lordship, without photographs.
It is your
cannot be
spouse.
issued.
Because
Because
not
earlier,
mentioned it in your tender.
yes, Lordship, earlier also they have submitted Lordship.
Earlier, so they have given a certificate, that photograph only.
Yes, yes.
You see what they, ground of rejection is at page 155. You see. With reference to your application, I am to inform you that geotag location photographs which have been enclosed along with your application under reference is on so and so. The site visit certificate of the photograph of so and so have also been issued by so and so. Then, so therefore, where is the requirement of a photograph?
Because it cannot be presumed by the department that the concerned contractor has visited
No,
the site
this is
without the
only
geotag.
for there as an undertaking so that later on he cannot raise the issue that this particular photograph had not visited the site. Because later on they come up now that the site was not properly done and all these things. So then later on they cannot come up and say that look here this site was not properly done and you have mentioned that this is the site. Here you have to do the work. Yes, sir. Later on, the tenderer cannot come up, and that is the requirement of a site visit certificate. Yes, sir. Now, they have given me, they have said that we have visited it. This is the photograph which I have visited. Photograph is not required as per the tender. You have made it in turn.
Every bidder who has participated in
Is not on there. Yes. Photograph is not required as per the tender commission.
yes, Lordship. Otherwise, how can?
That is your lookout. A person may go, person may not go, your person may also go there along with him.
Because geotech photograph is one of the mandatory clause.
Where?
Although it's not written in the tender.
Then how are you, means you are having a secret clause. And on the basis of a secret clause, you cannot reject. You dispose it of coordinate plans of disposition.
In some of cases, your Lordship had only part of the
Coordinate bench. I'm seeing a notice, let it matter, go to the coordinate bench. No, I don't have I have passed many orders, you have not produced, I cannot go to pass it on. Then why haven't you enclosed that? You also make it. The present petition is filed by the petitioner apprehending that the petitioner's application tender bid so submitted in pursuance to the invitation for bid dated 16/3/2026 could be rejected on the ground of non-submission of a fresh site visit certificate, site visit verification report. The brief facts which led to the filing of the instant petition are that a invitation for bid was issued by the Chief Engineer, Water Resource Department on six to 2026 for construction of embankment on L of river Ora Pagalpia from Food Warpit Beach to Triveni Ghat, including construction of sluice at Triveni Ghat. The petitioner being interested submitted its bid as it was a requirement of the tender condition, more particularly clause 7 of the instruction to the bidder. The petitioner applied for the site visit certificate by an application dated 10/2/2026. Along with certain photographs in respect to the location. Pursuant thereto, on 16/2/2026, the Executive Engineer, Nalbari Water Resource Division, Nalbari, had issued a certificate to the effect that the petitioner had visited the site on 10/2/2026 to study the site condition and local topological conditions, whether site is workable, accessible, public intervention if any, existing structure and its conditions, which may interfere with current proposed work, availability of construction materials as per the BOQ, and detailed requirement of the work for participating in the tender process. The said site visit certificate being relevant, the contents thereof are reproduced during under page 18. However, the said tender was cancelled and all the bidders were duly intimated by the communication dated 15/3/2026. In pursuance thereto, another notice inviting tender for the same work was another invitation for bid for the same work was issued on 16/3/2026. The petitioner having already visited the site and photographs were taken submitted an application on 18/3/2026 along with those photographs which were taken on 10/2/2026. The executive engineer, Nalbani WR division, rejected the application for the site visit certificate on the ground by the communication dated 25/3/2026 on the ground that on the ground that the photographs which were submitted were in respect to the site visit certificate which was issued on 10/2/2026 on 16/2/2026. It is under such circumstances the petitioner apprehends that the tender committee, the technical evaluation committee, while evaluating the tender, would reject the petitioner's bid on account of non-compliance to clause 7 of the invitation to bid dated 16/3/2026, and as such has approached this court. This court have duly heard the learned counsels appearing on behalf of the parties and have also perused the materials on report. In terms of clause 7, I, a Roman one, of the instruction to the bidders of the invitation to bid dated 16/3/2026. There is a requirement for the bidder to visit and examine the site of the work and its surroundings and obtain all information that may be necessary for preparing of the bid and entering into a contract for construction of the work. In terms of clause 12, capital A, P, small p, of the instruction to the bidder, there is a requirement of the bidder to submit the site visit certificate, site visit verification report issued by the executive engineer along with the technical bid. In the foregoing paragraphs of the instant judgment, this court has duly quoted the site visit certificate which is issued by the executive engineer Nalbari Works WR division. And from a perusal of this particular perusal of the particular, the perusal of the contents of the said certificate clearly show that the said certificate is for the purpose of an, is for the purpose that the bidder duly acknowledges that the bidder had studied the site conditions and local topographical conditions as regards the site pertaining to the workability, workability, accessibility, public intervention, if any, existing structures and its conditions, which may interfere with the current of the proposed work, availability of construction materials as per the POQ, and the detailed requirement of the work for participating in the tender process. Considering in the instant case that in respect to the same work, the petitioner have been issued the said site visit certificate on 16/2/2026. And it is the submission on the part of the learned senior counsel for the petitioner that the petitioner would not question if the work is awarded as regards the site conditions, as well as what have been mentioned in the site verification certificate dated 16/2/2026. It is the opinion of this court that the said site visit certificate dated 16/2/2026 can be taken into consideration by the Technical Evaluation Committee while processing the petitioner's tender, evaluating the petitioner's tender pursuant to the notice in the invitation to the bid dated 16/3/2026. Accordingly, this court therefore disposes of the instant petition with the following observations and directions. The site visit certificate dated site visit verification certificate dated WR/P-P-2019-G/2019/20/261 dated 16/2/2026 issued by the Executive Engineer Nalbari WR Division Nalbari shall be considered by the Technical Evaluation Committee in respect to the tender, in respect to the invitation for bid dated 16/3/2026 in respect pertaining to the work is workability. Be considered as the site verification certificate. Number 2. The petitioner would be bound by the contents of the said site visit certificate, verification certificate dated 16/2/2026. And the petitioner later on, if the work is awarded, cannot complain on the site conditions, local topological conditions, whether site is workable, accessible, public intervention, if any, accessible existing structure, and its conditions which may interfere with the current proposed work, availability of construction material as per the POQ and detailed requirements of the work for participating in the tender process. With above, the petition stands.
Okay. May I submit the document? If Lordship Heroes page 92, the bid opening date was 26/3/26. It has not been opened to, but I'm not sure. I don't have any updated information to you. Lordship,
It is further observed that if in the meantime, the bid had already been opened. Bids have already been opened. The technical bid as well as the financial bids have been already opened. The conditions, the directions, it would lead to third-party rights, creation of third-party rights. And as such, the above directions shall not apply.
Right. That case, again, would liberty may be given for, to ask for approaching this court again.
You know that it has been opened.
No, it has not. Then why do you need the legal?
What is it? This file, yes. Now, what were you saying with the 15 and also that passing out to submit the draft issue? All parties have done that. But, but, we were concerned with the, commercial code requirement. Perhaps we will have to file our admission in time. Where is the Is it prior to the draft issue? It is prior to the draft. I think draft issues would be the first stage of the case management. Yes, we'll have the schedule. Order 11, the amendments, perhaps now we are at the stage of order 11, rule 3. It is disclosure. Rule 3, rule 1 is disclosure. It's okay. Now we are at 3. Inspection. Yeah. But order 14 has not been amended. My lord, issues your lordship will find 15A. 15A is your lordship. Of this one, of that same schedule. 15A, 15A. Now this begins after order 15A. Then rule 2, A is framing of issues under court. Okay, so we have to go to number one first.
We'll have to go to number one, but before that, perhaps we'll have to comply with Order 11, Rule 4. 3 and 4 for a moment. Rule 3 and 4, inspection, and Rule 4 is admission and denial of document. We are now at the stage of Rule 3 because the WS against counterclaim is now.
Order 11, Rule 3.
3, inspection.
For the purpose of disclosure.
Disclosure, then inspection, then admission and denial, and then case management.
No, why do you say that disclosure is required criteria?
Look, we just wanted to file our admission and denial.
That's a different.
Yes.
Admission and denial will do that for other 12.
Yes, yes.
Here you will want to do, because here, if we say, the court shall hold the first case management hearing
Yes, not
later
later.
than 2 weeks from the date of filing of the affidavit of admission of by the parties.
And that affidavit of admission and denial, we are supposed to file
So
it.
you feel, one is for disclosure and
Yes,
discovery.
yes.
So if you don't want the disclosure or discovery, that is your look. Not here, I'm not going to compel you. Now, as regards the other thing, as regards admission denial, which is similar to this is discovery, into the trail
Admission and denial would,
inspection, you are at liberty to go. You are at liberty. If you want that to make a disclosure or you want some discovery, you go to change the expert of which is giving the affidavit, that is your look.
at this juncture, all parties, we were just,
You have to go to number 4.
Number
Admission
3.
denial. Each party shall submit a statement of admission or denial of all documents which disclose inspection have been completed within 15 days of completion of inspection or not later than by the statement of admission and denial shall state explicitly which
yes.
now you have to carry out this work.
We'll
That is
find
your
out-
record. If you don't want to do it, I will construe that you have not filed it. It is not requirement for me to say that date period. I will construe that you have not filed it. Why should I? The court shall hold the first date not later than 4 weeks from the date of filing of the affidavit of admission or denial. I therefore fix it for filing of issues in the meantime. You are at liberty to do 15A, 1 is your duty. If you don't do it, don't do it.
So we'll file our admission.
You don't go for admission. It is necessary for every party shall submit. If you don't submit, that is the because you know what is the consequence.
We'll do it.
We'll do it. So I fix it for framing of issue next day. In the meantime, you complete the formalities as per number 6.
Number 4.
And as per the formalities which are required, in the meantime, try to order 15A2. See, order 15A, order 15A1 categorically mentions that the court will put the first case after a management hearing, not later than 4 weeks. So I am having it after 4 weeks. In the meantime, whatever is necessary, go ahead and do it. If you don't do it, that is your thing. We'll consider that you are not doing it. I can't compel you. That's your look.
The only difficulty was when the suit was filed, that list of documents should also come in the form. That since it started off as a regular suit, that form was not there. And based on that form, we are supposed to do the inspection. then comes the admission and denial. But we will not object to them.
You know what to do. I am not here to aid or try to do anything. I am now next taking for framing of issue. I am taking it for take it.
Meanwhile, we have liberty.
In the meantime, you were to go for admission or denial. All these things, then you don't do it, then you know the consequences. We look into the consequences later. Isn't it? Word means
Harsha.
one to the learned counsel appearing on behalf of the plaintiff.
Yes.
Who is for the defendant? The defendant number one. One to appear for the defendant number one. Defendant number two. One to appear for the defendant number two. Defendant number three. Five. One to three to five.
Five.
What about three? No, three, four. Three, three, four, four, five. This court duly takes note of that the pleadings are complete. Under such circumstances, it is the requirement of Order 11, Rule 4, that the parties shall carry out the requirement insofar as admission and denial of the documents thereupon this court in terms with order 15A, capital 15, XA 15A. This court can take up the present proceedings for framing of the issues after examining pleadings, documents, and documents produced before this court, and on examination conducted by the court under Rule 2 of Order 10, if so required. The parties also shall be, the parties herein are also granted the opportunity of providing the draft issues. We find out. This court also duly takes note of that the party in the instant proceedings have already tried their draft issues, which shall be considered after the process of admission and denial is completed. Though it is the requirement that a period of 4 weeks should be granted. But however, on account of the summer recess of this court from 27th of June onwards till 12th of July, this court directs the parties to complete those formalities in the meantime. This matter again on 16th of July 2026, on which date this court shall consider hear the parties on preview of which.
Apply.
And the pleading and this part, the registry shall also prepare the file. There, does this court say anything else? No. Civil rules and orders? No. So it will be as per the civil rules and orders. Shall prepare the also a file in the manner mentioned in the civil rules and orders as framed by the Gauhati.
Right.
That would be fair.
Actually, in terms of lawsuit, last note I need at 2026, we have verified the office note as well as the list provided by the learned senior friend, our proposal.
Oh, this matter.
Yes, Lordship. And accordingly, we have served hotel, although we are supposed to file, serve 20 copy of the to the private respondent, Lordship. We have served 61, Lordship, as the sum of the respondents.
Anyway, everybody is paying.
Lordship, settled. And private respondents filed their affidavit, Lordship, yesterday. They have filed.
What will the private respondent say? If the government has affidavit is there or not? Is the government's affidavit there or not?
Yes.
Argue.
Led by learned senior person, James, Lordship, may
Hey, no, yes. Seeking adjournment in respect of any dispute matter we have seen in matter.
Lordship may fix the matter on Thursday, next Thursday, Lordship. In the meantime, we will
With the
file our
cost of
reply.
1 lakh. 1 lakh. Because it cannot be at your convenience. Do you think the court also have a convenience or not that the matters are fixed accordingly? There are a lot of other counsels are there. Getting hold of the advocate general is another big problem. Then 1 lakh. Next Thursday, 1 lakh. Argue.
In this case, we have finished the drive elicited by the state respondent. Our response, Lordship, in this case, some of the private respondents who have been selected, Lordship, they are, that time, Lordship, they are from the foreigners tribunal. They are a member of the foreigners tribunal. Lordship, which is,
Who are you? You?
we are, still now we are serving as a additional PP.
Additional?
PP.
And
We have participated in the selection process.
understood. So you were the additional PP. You're still PP. Now you want to be, now you have the age as per the rules. Huh?
Yeah.
What is the age for the as per the rules? You're giving the service. Well, how much? Mr. Dina, what is the age as per the rules? You have a rule, na?
40,
Age?
case 110, candidates should not be less than 21 years of age and not more than 45 years of age. As on 1/1/2004.
So the petitioner number 2 and 64 is out.
Yes.
So we are only at regard.
But and then Lordship, he participated in the selection process.
So what?
All the listeners.
You filed a petition, now you cannot get it. Can we give you now?
But at that moment, Lordship, he was also,
No, this court can very well set aside. We can set aside for at whose instance? But these two petitioners. Yes. Those two petitioners have no value. Why should I? Why should I issue any unnecessary writ? Now come to 1 and 4. 1 and 3. 1 has already crossed the age also.
in respect of the some of the private respondent, Lordship, in paragraph 22.
Yeah?
Paragraph 22. of our. Content is there.
So they are working in the foreigners tribunal.
Yes,
What is this basis you are saying foreigners tribunal serial number?
they are the, we have, it is the list also.
Where is that?
Is 144. 144.
Copy?
144.
What are
These are the,
the fact remains whether these people got the job or not? They were
these
given for
these are
one
the
year.
contravention to the advertisement also.
Sir, Mr. Koita, you are aware of it. What happened to these people?
They were selected also.
Elected the GPA.
They are discharged. That time discharged, they are
Where
discharged.
they out of it. A lot of people didn't even get a job or they did not create the 100 tribunals which were supposed to be constructed. Then what type of argument?
Oh, okay, they got the job.
Talk.
They got the job. Lordship, if Lordship the peruse the advertisement. 110.
So this is the only ground. And regard the 6.
And another one Lordship private person Krishna Gogoi, she was also discharging as DC Lordship designated. The last case, it was one case,
Why?
Krishna Gogoi, case 150.
What Google?
150. She is also added as a private person.
Krishna Gogol. He was at LPO.
Yes, that's all right.
PPL. What is LPO?
Is paragraph 23, legal cum probation officer. Paragraph 20.
PPL come probation officer. District child protection. Now let's see the advertisement.
Is 109. Another episode we have also already challenged the rules. Rule is already challenged before the building for the and the matter is fixed on 22. So paragraph is 112.
What is the advertisement is this 109?
109.
What is the requirement? What is the bar?
Three categories are my clothes, the public prosecutor, additional public prosecutor, and assistant public prosecutor.
As the practice is an advocate for not less than 3 years, including practice before the High Court. So tell me, what is the problem with this? Was it
Subclause 8, Roman 4. 112.
maximum is
112. Documents showing, eight documents to be submitted. Newly filled up application form affixing a self-attested photograph on the top right side in the form, along with the self-attested photocopies of the following document certificate. Roman 4. Documents showing date of enrollment with a self-declaration that after enrollment, she has not left practice as advocate and has not joined any other service of the profession business. In case contrary facts to such claim comes to for subsequently, his or her candidature shall be rejected and may even lead to termination from service if detected after joining service. So apparently, lots of those private respondent. 22 and 23.
it is a termination.
So in respect of that, regarding their affidavit, they have got, there is no contrary possible. Respect of the paragraph 22 and 20.
Is it your statement that they have not given that self-declaration?
Lordship, paragraph 22 and 23, not replied.
Forget about that. My question is it your case that they have not given the self-declaration?
Lordship, if self-declaration given, then we might not, Lordship, selected.
No. Why ifs, buts and all? My question is it your case that they have not given the self-declaration?
Yes, Lordship.
Where is this?
Because
No,
they have
not because we come to the point.
paragraph 22 and 23,
Let us see
Lordship,
paragraph
we have specifically avoided, Lordship.
Now 20. That the petitioner
Begs to state that gross violation of clause 22. Several candidates who were already serving as member of foreigners tribunal under the government of Assam and
So-
who has
No, where is the bar in selection? And the advertisement, it is the mandate every year to also have the every year. Submitted that these mandates to be given for who were previously appointed the year. Where is your statement out here that they did not do the self-declaration?
so
But records we will all
But-
provided,
but-
no, Mr.
but
Kunta,
ultimately
we will
those
call
private
for the
respondents were selected.
reports provided.
Either
You
they
will
have,
make an allegation.
either they have not submitted that self-declaration.
I mean, where is the, why should we go into those realms unless and until you make an allegation that they did not?
Ultimately, we have released this in our requisition, Lordship. There is no contrary submission.
What is your submission? What is your allegation out here at paragraph
because Lordship,
22?
ultimately,
No, have you mentioned that they did not give the self-declaration? What is required is what? Let us see. The document showing date of enrollment with the self-declaration that after document,
after enrollment,
enrollment, he has not left practice as advocate and has not joined any. In case contrary facts are proved, then they will take action.
ultimately,
My question is, is it your case there was no self-declaration?
if ultimately, yes, Lordship, because ultimately if left a job, Lordship, Lordship, the respondent cannot
No,
select it.
Mr. Kunta, this is not a proper submission. Because what is required? Let us see. Just for example, see the qualifications are required. For PP 109. Must have practiced as a regular advocate for not less than 8 years, including practice before the High Court, basically on the criminal side. Okay. Now, just for example, for a case like me, I am saying that a person, I have practiced for 8 years. Then doing some other jobs out there, somewhere, Hong Kong and all, I do some jobs. And then come back. Again, I join and become a PP. Can I get it or not?
Lordship, both are Lordship contrary because.
No, my question is this. I may not get it. If I have given a false declaration, I may be terminated. That's a different thing. But whether the selection is bad for that, unless you allege that there is no declaration.
Lordship, apart from that down, we have also alleged that Lordship, in respect of the call letter, shows that the judgment requirement of the judgment, Lordship. Most of the selected candidates, they have not provided that judgment, Lordship. In
Where?
respect of, if Lordship shows the
To me, which are the judgments required as per the advertisement?
call letter, Lordship. One 22.
No, advertisement. First, let us go by the advertisement which requires judgment.
There is no requirement in the advertisement. Subsequently, call letters, by of the call letters, they have instructed.
Yeah. Any
Case 119, or case 120.
Page
Case 120,
152.
120, clause 4.
All are same.
In respect of
Every candidate
120 is the
required to
for
produce
additional
the
public prosecutor, whereas
of any order, judgment passed by court of law in any criminal proceeding in which the candidate himself appeared and conducted an argument.
in respect of the rules, Lordship, we have alleged that most of the candidates, they have failed to produce their judgment, Lordship. Because
Which are the candidates?
if ultimately,
Don't, Mr. Puncha.
immediately,
No,
Lordship,
you are asking this court to exercise 226 with very vague allegation. Which are the candidates who have not proved?
So ultimately, in our Christian lawsuit, we have covered it, respondent produced that records lawsuit. Why? Because we
No,
ultimately.
no. First of all, you cannot make an omnibus statement of the saying that most of the candidates have not produced these 4 judgments of the criminal side. It could also include a bail. Didn't it? Criminal side bail argue. I don't know much who argued because I don't sit in that bench. But otherwise, did the selection committee who was there after it was stated some judges were here, so that's where those judges from the criminal side were taking up. Criminal,
Not say that, yes,
We're taking Justice C.R. Sharma, criminal income of Labura, and minor justice Anima.
Nima, Nima, I think about the.
C.R. Sharma was there, and minor justice Sundar Malhotra.
At that point
Three
of
board,
time,
three interview boards were there, headed by the 3 judges.
okay, they
I'll
have.
make my submission at this point.
I may not know. So, you can't make big image. These are not. You have not made a categorical submission that these are the candidates who did not submit the. Your cases, they are working. Yes, maybe. But the fact remains whether they had these 8 years of PP, whether they had these 5 years as PP, additional PP, and 3 years as so and so they have worked. They may be doing many other works also. Now the question is the selection which is subjective. So, and out of that, 4, 2 has already gone for a 6. Who cannot appeal? Who have no Lucas? 2 petitioners.
Yes, out of
You got all those 2 persons. Could have got better person. Close it.
last submission document, will come at our Thursday. So we are late by, when I see you guys again, so because that is not just yes. Also, they pick up at our Thursday.
These are the 2 allegations.
And regarding the rules,
The
regarding.
rules I am not. Rules is for the division bench. I have nothing.
And the matter is 6 on 22.
Yeah, hardly matters whether the division bench, whatever they do, that is their local. I am not on this. If the rule goes, entire selection will go, but I did not wait for that. Because I think this matter was initially filed before the division bench and the division bench sent it to me
Because
for doing the, taking up this matter. So therefore, when the matter has been taken, given us to us, it is with an implicit a mandate to decide it. Yes.
they may take the matter at 2 o'clock. It's not coming.
on Thursday, also.
Again, Thursday is long. Because these all these candidates, their training is over now, they are placed. And I gave an undertaking before this Congress report that we are not going to touch all the existing TPs.
No, that
Like that.
no, in fact, I have recorded in.
Yes, but now the thing is very difficult. I have to withdraw that by proper application. Because when we have allowed these newcomers to join and go there, they are not allowing them to enter the premise also, not allowing them to sit in the room also, not parting with the files also. We'll come back on that point. To a different.
That you take it up on 18. Another thing, we pass on to get on direct.
We wanted the hybrid system should continue. They are not parting with
Because
the.
I have duly reported that.
Yes.
You are.
And the instructions I have.
But there was an affidavit filed by the home and political people.
Yes, yes. We wanted everybody should sail together, but now they are creating a problem. The existing, the earlier. This is a new development. Then they will have to face the bill.
Already gone. Remaining 2, what remains? No, if you come up with this vague allegation, what is the?
Possibly fix the matter on Tuesday.
We are already working.
Yes, sir.
Then, what is there? You are getting case wise. They are getting it salary after such a person. Can't get a salary. This, if he gets case wise.
They have to fix
As
it.
per the old regime, if he gets what?
They are well paid off.
No, no, do they get per additional PPs, they get it case wise or salary?
The new ones,
No, no, old one.
retainer, one amount is retainer,
And per case.
amount is per case.
And here it is salary. You want the salary.
And why we have started this process, the story is very different. The state government with the chief minister, he conducted some meetings with the speakers and the deputy governor, and found that several districts, the PPs are not getting salary for last 11 years, 12 years. And nobody is objecting. Not submitted their bills also. That prompted the government, that triggered the government to go for the regular recruitment. They will be all employees now. They will be transferred. They will follow all the service rules and conditions. So without any payment from the government, they are doing service. This is not social. Possible understand what I am. 12 years, they are not submitting a single bill. And they are happily performing their duties. That happily is happy for them, not for the figures we want for conviction. And after the recruitment, now the government has become a little bit stringent. So from 6%, it has already risen to 26% in a period of 1.5 years, the conviction rate. And we are targeting 70 to 80%. Trying to match the NI and CBI's level of conviction. The coming 1 or 2 years.
So point I make it very clear. Let's you can't come up with big allegations. With big allegations, I'm not going to agree. Okay, you want it to be done on that next stage, we can check out, but I make it with these allegations. Today, I would not anyway decide this matter totally because today from the morning it has something is going on. Like first item, he didn't have a good kid. He should have argued that point and he was arguing or not, I couldn't hear because of his voice. Anyway, I dictated the entire thing. And when I was seeing, oh, this was the point you should have argued. The entire judgment I've given and last point, I finished it up, yes, allowing his petition to sit. Next comes the motion of the petition. He says that this is citing everything like that. After long order, last moment, Mr. Arendra said, it must have been over. So last line I have to read, whatever order has been passed would not apply if it is not finished. So therefore, my day I want to Thursday, it will be over. Because without these allegations, it's very difficult, Mr. Counsel. On the last occasion, who have made that submission, which I recorded with Mr. Kane Chaudhary, the selection process was not proper. But there you have to pinpoint what are the things which are there. It is also that person working out there, no well, and if it is there. You see, tomorrow, as per clause 8.4, person has not given a false statement. You can very after being appointed also you can file a writ of quo warranty. But would it be wrong with the selection process? Making allegation that they don't have appeared in these examinations, there we are, that is very. Anyway. The Advocate General will have this matter on Thursday. No more adjournments. The petition having been partly heard, this matter on Thursday at the top of the list. Today is Thursday, not Tuesday.
Or Lordship may fix the Tuesday also.
So late. Tuesday also.
He's taken it over. Top of the list. Top of the list আছে নেকি? নাই। নাই না? Top of the list. Where is your junior who appeared on that day? Miss K. Khan? Where is she? Oh, I can't take up the matter. I told her she has to appear. What's your instructions? They're agreeing. So we close it on the basis of the affidavit and quote it, the relevant portion.
Whatever is, I am entitled under the policy, I'll give.
But they say in this affidavit, and that's why I gave you the opportunity. And let's see the benefits.
Yes,
Able
ma'am.
to pay 150. So now you will be paid 37 lakhs a month.
Yes,
So plus you die early, then people get 50 lakhs. You die late, you get 100, you get 2,75,000 PUI.
if I may pray, madam, that for the delayed payment, I'm also entitled to interest.
Huh?
That part they have not incorporated.
No, that was the
Because of
disputed.
delay.
tax, but that may not be.
I think that needs to be closed. I think we close it with.
Fine.
The petitioner in the instant case. The petitioner has approached this court seeking a direction upon the respondent LICI to release the petitioner, the benefits of the petition of the LIC policy number 493566060 the Jivan Darang scheme. And have also sought for setting aside the illegal assignment as well as the letter dated 16/2/2019 issued by the respondent number 2. The records, the affidavits which have been filed by the respondent number 2, by the respondents, and more particularly the affidavit filed by the secretary, any legal cell Gauhati of the respondent. Number 2, na?
No, he is not the party. He is filing on behalf of.
On behalf of whom?
One
Respondent
to
number
four.
2.
Yes, 1 to 4.
On behalf of the respondent number 4, being the competent authority. Clearly goes to show that the respondent numbers 1 to 4 are willing to make payment of the petition to the petitioner. The dues in terms with the policy number 4935 66060. Paragraph number 4 of the said additional affidavit being relevant. Said additional affidavit filed on 3rd of June 2026 being relevant is reproduced here in under. This code also really takes note of when the writ petition was listed on 9/6/2026. The counsel for the petitioner was directed to obtain instructions as to whether the petitioner is satisfied with the amount which have been mentioned at paragraph number 4 of the additional affidavit filed on behalf of the respondent numbers 1 to 4. Ms. P. Chakraborty, the learned counsel, appearing on behalf of the petitioner, submits that the said amounts mentioned in paragraph number 4 of the additional affidavit is in terms with the benefits of the policy bearing number 4935 66060. Accordingly, the instant writ petition therefore stands disposed of, thereby directing the respondent numbers 1 to 4 accordingly. This court construes the statements at paragraph number 4 of the additional affidavit to be an undertaking before this court. Next, the writ petition accordingly stands disposed of with the direction upon the respondent numbers 1 to 4 to make payment to the petitioner in terms with the undertaking mentioned at paragraph number 4 of the additional affidavit filed on 3/6/2026. And the relevant portion of the portion paragraph number 4 quoted herein above of the affidavit dated 3/6/2026 filed by the respondent number 1 to 4. The same shall the payment of the amount of rupees 37 lakhs 05,000 be released to the petitioner within 4 weeks,
2 months.
2 months, 6 weeks, 6 weeks. From the within 6 weeks from the date of the present order. The other benefits which the petitioner would be entitled to be paid in terms with the policy as mentioned at paragraph number 4 of the affidavit dated 3/6/2026. Thanks, Lord.
Senior Mr. H. Gupta is in legs in another court. Matter will be taken up after some time.
Here we are giving officers two letters whereby the petitioners were placed under negative list is what they try to construe as illogical.
Who is the other side? Alicia.
PRO. PRO.
do they say?
They, no, all the documents that they have annexed, all are prior to the cases that we have instituted. Your Lordship. And they say there are ample opportunities that were given to cure their defaults, etc. Your Lordship, to the petition.
But these are all okay, but wouldn't
Are-
this come within the ambit of
Basic contention is that in both these letters, we have not been so called and have been placed in a list similar to blacklisting us during the execution of takeover.
which is the clause you are referring to, 23.1?
That page 23, 153.
Authority may at its own way without terminating the contract and allowing the contractor to continue with the existing contract, pay the contractor in the negative list or any of the following reasons. Within the power exercise,
Yes, Your Lordship, but
provide the authority
They have not
to issue a notice giving 15 days to the
Yes.
contractor before proceeding. That proviso is not carried out. Okay, we take it up after some time. Oh, this matter, whatever.
In fact, substance in this matter, great lordship of some time. But the last time the lordship has asked for seven. Information.
Court is of the opinion that the stand of the Ministry of Human Resource will be essential while deciding the issue, more particularly when respondent number 4 has 24 research institutes in the collaboration with the state government, and in this 24, the age of retirement varies from 60 to 55 years. The learned counsel submits that the age of retirement varies with various research institutes, including to various state union laws. The instant case, as in the state of Assam, the state university norms is 65 years for professional, the age of retirement. In view of the above, this court therefore repeats the Union of India. That being on record its stand and more particularly as to the age of retirement of professor in a research institute sponsored by the details of available in the communication. Now what to do? Don't delay. This is, you see, the problem is, Mr. Chaudhary, the problem is it's an embarrassment for this court in respect to the present case, taking into account that this court,
It has fallen from your.
you see, a judgment was concluded on 19/9/2024, and thereupon matter, there was no judgment delivered till 27/8/2025. And it is not done.
One opportunity.
Just because it is very, otherwise very embarrassing. Take the embarrassment of the court into consideration.
I will do the research. Just rely upon.
Somebody has filed for visa. In fact, the entire issue has been put in my order of 21/4/2000.
Yes.
I gave you time, this
Only on the basis of that communication 3011.
3011. Well, then 3011 is the catch point. In fact, they should have made this union party at the first instance.
But at the time of filing of the petition, petitioner was not having this document file. At the time
Oh.
of filing of the petition, subsequently,
Whatever maybe
yes, my lord, that is done, yes, my lord, I agree with them.
3011, where is that document again?
Page 455 in the affidavit. There is a separate affidavit file is there.
465.
455. Start. And the relevant part, 457.
Getting filing. I fixed it on 14th of July. Mr. Architect from Rotary, learned ESC I and GI. Again, the standing senior counsel. Hearing on behalf of the respondent number 8 submitted that though the order dated 21/4/2026 was duly communicated, but he is yet to receive the instructions for filing the affidavit. It is the opinion of this court that the affidavit of the respondent number 8 is of vital significance for the purpose of deciding the present dispute. And the reasons have been clearly assigned at paragraph number 7, 8, and 9 of the order dated 21/4/2026. This court also duly takes note of that the present petitioner approached this court at a time when he was serving as the professor, na?
Yes.
Of the professor of the institute in question. On account of the pendency of the writ petition for the last 4 years, the petitioner is presently no longer in service, inasmuch as the very issue as to whether the age should be 60 or 65 years have not been decided by this court. Mr. R.K. Dev Chaudhary, the learned DYSDI submits that without fail, the affidavit would be filed on or before 13th of July 2026. This court taking into account that the right of a person which is sought to be a right which the petitioner have sought to be adjudicated upon has to be adjudicated within the time frame directs the respondent number 8 to file the affidavit on or before 13th of July 2026, failing which this court may be constrained to pass appropriate directions. List again on 14th of July 2026 at 2 p.m. 2 p.m. or top of the list? Top of the list. For final dispute.
May I please you not see? Director extract, so kindly allow 2 weeks time to file fresh Okalatnama.
What?
Fresh Okalatnama on behalf of the new director.
Here we have challenged the part of the award.
Only modify the award dated. Restore the service without backwards. Only modification of the award. So kindly allow 2 weeks only to file fresh Okalatma on behalf of the new director. Your
Why?
Lordship, kindly. Earlier director expert, so how can I ask the on behalf of Okalatma? Only 2 weeks.
Is it necessary, my lord?
Yes, your
I don't
Lordship.
think it's necessary.
Director expert, new director appointed. He may be appointed me or may not be appointed. That's why only 2 weeks. Only 2 weeks. Nothing else, your Lordship.
He has appointed you.
Earlier director appointed me. My name is B. Sarkar. So only 2 weeks, not more.
It belongs to a company.
Yes.
Select the company.
The money never please.
So as per you, you are entitled to the back difference. And as per me, the award is wrong.
Your lordship has the reason to say so. But I will take your.
But they have not challenged it.
They haven't challenged, apart from that, my lord, section 33 has not been considered at all. Which is
Whatever
the.
may be, the question is, he went into the domestic inquiry and held it to be bad.
Yes. Yeah, that's the point your lordship is thinking.
And thereupon the question is how, without discussing any further thing, how could he pass that order?
Very right. But then your lordship is.
He has not
absolutely
challenged.
correct.
He has not.
They are challenged.
In such a long order. Full matter.
Yes, only 2 weeks. This is long pending, I know, but only I pray 2 weeks, nothing more.
Why is the new director telling you?
Date may be fixed, your Lordship.
Is the new director telling you that look here, the old director, whatever promises he has made to you, he's dead.
As per your Lordship, you. As per
Is it something like that?
kindly allow me.
Okay. It is submitted by the Mr. Submitted by Miss So-and-so, who appears on behalf of the respondent number 1, that she requires 2 weeks' time to prepare the matter. This court duly takes note of that this is a case, this is a labor dispute pending since 2008. Considering the above, this court grants a final opportunity to the respondent and fixes the matter on 16th of July 2026.
18, your Lordship, and 18.
What?
18 July. Oh, no. Sorry. I say 16 June. Sorry.
16th of July 2026. There shall be no further adjournments to be granted to the respondent on the next date.
Highly honorable, sir.
I cannot write about that wakalatnama because that is thing which is not conceivable. What is this matter about?
Matter pertains to the reservation under section 33 of person of disabilities.
Huh? Calling upon the response to suppose in the nature and written to why select is dated so and so declared by the website of the year should not be quashed and to why the respondent should not be directed to place. Have these people been appointed on the basis of the select list?
Yeah.
Then
My lord,
I'm not going to set aside this.
no, my lord, as per order dated
After
8/11
10 years, I'm not going to do whatever it.
50, there were 51 posts advertised. 50 posts filled up, one post could not be filled up because of, there was, MACP 4 port was not established at that point of time. There was a direction by the honorable court also at the very beginning.
8/11/2017, my lord, order dated 8/11/20.
Want to fill up the 51st post. 51st post.
Only because of that, the matter is surviving, my lord.
What post?
Issues with
That
regard to-
order, my lord.
issues with regard to not making reservation.
No,
for
no, no, no,
PWD.
it is, you did not, you could not participate.
I have participated, but I'm a person with disability under that category, my lord.
Hmm.
But no person was appointed under that category, my lord. So although 51 posts, out of the 51 posts, my lord, 50 posts has already been filled up, my lord. Only one post was still vacant. So as per order dated 8/11/2017, my lord, as by this honorable court, that post is still vacant, like. Kindly
And what
that
is
order-
his selection process?
And then other candidates, they got appointed.
No, not about the others, about one post.
This one post will have updated, I don't have instruction, but my affidavit says that the MACP port, that port was not established, because the infrastructure was not there, so that's why the last post was 51st post was not filled up.
You are what?
I'm a candidate. I have already participated in selection process, my lord.
Did you participate as a PWD?
Yes, my lord. I participated as a PWD candidate, my lord.
Where is the advertisement that they, you are saying that the advertisement, there is no PWD?
Yes, my lord.
Huh?
In the my lord, Annex 5, page my lord,
For
18.
filling up 397 posts.
Yes, entire Assam. That is the establishment of subordinate judiciary in Assam.
PWD 18 is there, na?
My lord.
In the advertisement, Annex 5,
Yes, my lord.
there is one 18 posts, so what? I
No,
mean,
That is
how many posts?
That was there in the
category
advertisement.
is the last date of receipt of the application are in the age. So there is one post, is there no post for PWD?
No, my lord, actually establishment wise, the act says it has to be done establishment wise. Lord, I have, in my affidavit, I have given the establishment, one post did not come. Our vacancy were advertised establishment wise. It contained along with the advertisement, which they have filed in the requisition, another notification was there, which shows the establishment wise vacancy. So in establishment wise vacancy, if we calculate 3%, did not come one post.
So one post is left.
One post is vacant, but that is not with regard to the PWD.
Vacant.
Yeah, post is vacant.
So we don't set aside the selection process. We do one thing. Oh, that post fill up by applying PWD.
Not because I just
No, there has to be a PWD.
what happens in this, this is one of those initial centralized selection at which point in 2015, the notification for identification of the post was not there. The Gauhati High Court notification identifying as per the act that came in 2017, that notification I have made. Now, till that time, that notification was not there, identifying the post. So as per the act, identification is a must. Then only the PWD reservation can be given.
PWD will be horizontal. Horizontal. Now, if it is PWD horizontal, this post is vacant. Now petitioner will be how much? 30, 43. 43. You can get till 48.
I can participate as per the.
Yes, and all this while you have not participated in any other thing.
Yeah, sir, I have participated, I'm not selected, but since the petition has been filed.
Very difficult. Here,
Because there is one
judgment.
order, my lord.
There is one, the PWD Act came in 2016, no? No, PWD Act came
17.
when?
16, 49 of 2016.
16, yeah.
Yes,
So
2016.
this advertisement was done prior to that act.
Advertisement was done, yes, my lord, 2015, my lord.
So therefore, at that point of time, whether the constitution permitted or the law permitted a reservation, horizontal reservation or not?
Their identification notification, 2017.
No, understood.
Yes. Prior to the 1995 Act of Bill. This is the first exercise. That is the judgment. For the first time in 2017, this identification process was undertaken and posts were identified.
And what is your disability?
Disability pilot, locomotor, orthopedically handicapped.
Huh?
Locomotor.
Locomotive.
Yes, sir. It will be like OHP.
We don't come within it. For computer
typist.
there's no course for computer typist here. Computer assistant is. Typist will be different. Huh?
Yes, ma'am. The advertisement was for computer typist.
Understood, but this thing is no computer typist.
No computer typist. Yes.
Computer typist was not there because the rules would not permit. And that is why we see
Office typist and computer typist. Yes, ma'am. But the thing is that the important aspect is that, my lord, without identification, PWD reservation is not permissible because Act says the identification has to be there. So identification came in 2017.
Obviously, the advertisement which was made at that point of time.
Yes.
The PWD Act did not
Was
come
not
in.
there. In fact, one judgment.
So at that point of time, if there was no right,
Yes.
then the state would have done so under 16.4.
Yes.
16.4, the state could have done so, yes. But without the state way, this court can't issue a mandamus.
Same thing has been said in the judgment that I had raised.
Under the law. The law was made only in 2016.
Directly. In the judgment of this Nikki Hussain, the para 9. I'm so sorry. Our High Court review. Over. Para 9.
Is not reported anywhere.
I'm so sorry. Let's, we've taken pretty long back so that we mean it.
What is it? 1995 Act? Oh, okay. PWD Act is of 1995.
Yes. 2016, the new act came. Prior to that, 1995.
Okay. So 1990, we have to look into as per the 1995 Act.
1995.
Whether there was a right in there or not. For in view of paragraph 9, you are relying on paragraph 9.
Paragraph 9, Milord. In view of that act also, Milord, the identification has to be there.
In absence of any steps having been made by the respondent pursuant to the requirement of the 32, no reservations could have been made. So whose duty it was to make the carry out the exercise?
But it's the duty of the state. But
It means you.
yes, Milord, it's the
So
duty of
therefore,
the state.
you, because of your fault, why you should
That is true. That is true. But without any identification process.
No, therefore, if you today also say that we don't identify. Then Can that be the reason
At-
why?
That point of time, my lord, the
They did not
identification
think that
came only.
people are important. Guwahati High Court, sorry, no? If the Guwahati High Court thought that PWD people were not important at that point of time, and now they give importance.
No, my lord, immediately after the coming of the act, 16 came and 17, we have done the identification. But unfortunately, during this period of time, the identification was not there. And for earmarking vacancy for PWD, as per the act, the identification is the sign of the.
So that's the problem is the law has much evolved in the meantime from 2016 onwards. The importance which have been given. In my opinion, to say that the High Court did not carry out the identification because of that the petitioner was not taken into consideration or the advertisement did not have this say may not be so proper. I think the best option is one post is already vacant. Fill it up through PWD. Now you identify and fill it up.
That can be done.
Because that is the, you see, from 2016 and thereupon the various judgments, Supreme Court has been very strict on that. Yes. On PWD.
Yes, one judgment I have below 2023.
For this court now to say, hey, identification not done, and that is not be portray a good picture of the Gauhati High Court.
But in Annex 3,
So fill it up. Now you do one thing.
No,
That
Lordship
post
is
is
correct.
vacant because
I agree.
one post, that post is vacant. So
Can be
if
filled up.
you fill it up by identifying the
Yes,
post somewhere,
yes.
that post, and thereupon give the petitioner an opportunity of applying along with others.
Yes, that can be done. That can be done.
We are not going to touch that.
Fine.
I think that is a requirement which should have been done.
Yes. That can be done.
In the council, that is the only.
extra 43, page number 43, my lord. Here, Guwahati High Court has already appointed in 2017, my lord. PWD can remember the reservation of PWD. Annex 15, page 43.
Mr. Council, that is what Mr. Das has tried his throat to say. That look here, from 2017 onwards, we have made the identity. Prior to that, we have not. That is what he is saying. So therefore, 2017, there is no problem. But the fact remains that there is one post vacant. So let them identify the area where that post of PWD can be inserted, and they will invite all, including you. And if there is an age relaxation, kindly give it to the.
Yes, yes, right, because 48, that is a limit, my lord, as per
Huh?
advertisement. Mine of 43, my lord. So as per
But
this
then
rule,
also
my
you
lord,
can get till 48.
yes, sir.
That's okay. I'm not on that. But then also, if there is a necessity, yes, that was 48 then. Now it is 48. Okay? Sorry, is it 48 now? No. What is the present standard? We have put it on 45 or 46.
48 million.
As of now also. No, then is okay.
Then, but I think it will remain for PWD in the act itself. I think it's-
So, see the act, what is it? So the age relaxation also comes within the ambit of 16 code,
Yes,
unless the act says. I don't think the act will say. Act doesn't specifically say.
so there is a provision, my lord, 34 3, the appropriate government may by notification provide such relaxation of upper age limit for employment of person with benchmark disability as it thinks fit. I think after this, there is a notification.
Therefore, I'm saying, na, this has to be, this is there, so this power has to be exercised by the state under 16(4).
Look, I have just one 2023 advertisement wherein below the upper age limit now it's 50, if we say maximum 40 years, then 10 years upper age limit relaxation for PWD candidate,
3 years,
10 years.
so it will be 50.
Yes, ma'am.
But this must be based upon some notification. Anyways, we make it clear that you give him the.
Yes, that will do me. That will do.
I think that is better. But why this matter has been hiding all this? Why?
Not, it was listed after very long time. Not 1.5 year, 2 year.
This should have been finished up then also.
Yes, my lord. After 17, then 20, then 24.
Heard Mr. So the learned counsel appearing on behalf of the petitioner. Mr. H.K. Das, the learned senior counsel, as well as the standing counsel of the Gauhati High Court, assisted by so-and-so, appears on behalf of the respondent number 2 and 3. And Mr. M.C.T. appears for the respondent. The petitioner, with a person with disability. What disability?
Locomotor.
60%. Yeah.
Page
The person with
Page 70.
with locomotor disability, and more specifically OL, there's one leg affected, isn't it?
Yes.
Is aggrieved by the non-consideration of non-inclusion of post non-inclusion of the reservation in terms with the person with disability bracket equal opportunities from a protection of rights and full participation Act 1995. In the advertisement dated 7/9/2015, and therefore have challenged the said advertisement and the consequential selection carried thereupon. The materials on record shows an advertisement was issued on 7/9/2015 for filling up of 397 posts of computer typist for the subordinate judiciary of Assam. In the advertisement, though, there is an age relaxation provided to person with disability. But the same advertisement did not mention that there was a reservation for persons with disability, isn't it, Mr. Bhatt? Be that as it may, the petitioner submitted his application
as a normal candidate.
Actually, I have applied in the PWD candidate actually.
How could you apply? Your acknowledgement card does not show anything.
My doctor. But since my eligibility certificate.
There's no quarrel. You apply.
As in the advertisement, it was mentioned that as the reservation will be as per rule. So we have applied.
There was no advertisement. There was no specific. Reservation for the PWD person with disability candidate. Though the advertisement mentioned where
In the page number 18, madam, it's a five, last line. First paragraph, reservation of the post for different category duty as per rule.
but the advertisement categorically mentioned that the reservation of the posts for different categories would be as per rules. The petitioner applied pursuant to the said advertisement. And was issued an acknowledgement card. The said acknowledgement card has been enclosed as Annexure Roman 6 to the petition.
Also, my lord, I have participated in the skill test as well as written test. My lord, as per annexure 7, that is the result of.
It's okay.
test. To go there, yes.
The perusal of the acknowledgement card, however, does not show that the petitioner was categorized as a PW person with disability candidate. Be that as it may, the petitioner participated in both the written test as well as
Skill test.
skill test. However, the petitioner was surprised to learn upon the select list being published that there was no reservation for for persons with disability who have been selected. That there's no persons selected as per belonging to persons with disability. The reservation was applied vertical reservations were applied for OBC, SC, STP candidates. And there was no reservation, horizontal reservations. Being aggrieved, the petitioner therefore approached this court by filing the present petition. It may be relevant at this stage also to take note of By an order dated 8/11/2017, notice was issued. On the same date, when the matter was taken up by the learned coordinate bench, it was informed that out of 51 posts advertised for the Kamrup District Judiciary wherein the petitioner applied for, did you apply for district-wise? Only 50 numbers of appointments were made and one post slated for the MACT court was kept vacant on account of lack of infrastructural facilities. The learned coordinate bench thereupon passed an order on 8/11/2017 itself that the 51st post advertised can be filled up by the respondent number 2 and 3 herein. By carrying out an exercise the learned coordinate bench of this court directed the respondent number 2 and 3 that if the said respondent intended to make any appointment to the 51st post advertised, an exercise be made to arrive at a conclusion as to whether the said post ought to have been reserved for the physically challenged person under the Act of 1995. This court have also taken note of the affidavit filed by the respondent number 2 and 3 in the instant proceedings. Wherein it was mentioned that the petitioner lacked merit or the unreserved category candidates. And as such, the petitioner could not have been selected. It was also mentioned that the question of the petitioner being selected as a PWD candidate did not arise, and the question of the petitioner having a grievance for not being selected as a PWD candidate did not arise. Inasmuch as no PWD candidate were inasmuch as there was no reservation for PWD candidates in the establishment of Kamrup Metro. Today, when the matter has been listed, Mr. H.K. Das, the learned standing counsel of the Gauhati High Gauhati High Court has submitted that till date, the 51st post is yet to be filled up. This court have duly heard the learned. The, the further submissions so made by the learned counsel, standing counsel for the respondent number 2 and 3 is that at the time of the advertisement, there was a requirement of identification of the post, which can be reserved for the PWD. And the said identification being not carried out prior to the advertisement, there was no reservation for the PWD. In that regard, the learned counsel have referred to a judgment of the court-made bench in the case of the Gauhati Mohammed MD Nakib Hussain versus the Gauhati High Court and others. This court have duly heard the learned counsels appearing on behalf of the party and have perused the materials from report. The person with disabilities, bracket Equal Opportunities, Protection of Rights and Full Participation Act 1995. Was enacted pursuant to the meeting to launch the Asian and Pacific Decade of Disabled Persons 1993-2002 convened by the Economic and Social Commission for Asian and Pacific Region held at Beijing on 1st to 5th December 1992. In the said meeting, a proclamation was adopted on full participation and equality of people with disabilities in Asia and Pacific region. And India was a signatory to the said proclamation. The statements of objects and reasons of the Act of 1995 specifically provided the reasons as to why the said Act of 1995 was enacted. They were, number one, to spell out the responsibility of the state towards the prevention of disabilities, protection of rights, provision of medical care, education, training, employment and rehabilitation of persons with disabilities, semicolon. Number two, to create barrier-free environment for persons with disabilities. Number three, to remove any discrimination against persons with disabilities in the sharing of development benefits vis-a-vis non-disabled persons. Number four, to counteract any situation of abuse and exploitation of persons with disabilities. Number five, to lay down a strategy for comprehensive development of programs and services and equalization of opportunities for persons with disability. Semicolon. And number 6, to make special provisions of integration of persons with disabilities into the main social mainstream. The Supreme Court, in a recent judgment in the case of Ajay Kumar Pandey and others versus State of Uttar Pradesh and others, reported in 2023 16 SCC page 82. The Supreme Court, in the case of Union of India versus Ravi Prakash Gupta, reported in 2010 7 SCC 626. Observe that it cannot be denied that unless posts are identified for the purpose of Section 33 of the Act of 2015, 1995, no appointment from the reserved categories contained therein can be made, and that to such extent the provisions of Section 33 are dependent upon Section 32 of the Act of 1995. Further to that, in the judgment of the Supreme Court in the case of Ajay Kumar Pandey and others versus State of Uttar Pradesh and others, reported in 2023 16 SCC page 82. Also observe in connection with Section 32 and 33 of the Act of 1995. Last two lines. Very few. That the state government has to take a conscious decision to reserve certain posts. To observe that there's a requirement of identification. to be carried out by the state government. It will further observe that once such exercise is being carried out, the appropriate government in turn to section 33 of the Act shall reserve 1% each for visual disability, hearing impairment, and locomotor disability. The identification of post and the category of the disabled candidate who could be appointed against the post reserved is the power conferred on the appropriate government. This board further takes note of that it is the requirement that taking into account the scope and ambit of the Act of 1995 and the reason why the Act of 1995 were at all enacted, a positive obligation is cast upon the appropriate government in terms with section 33, section 32 and 33 to identify the post wherein the persons with disabilities can be accommodated so that these persons can be given an equal opportunity. In the instant case, it is seen that there was no identification carried out and resultantly no steps were being taken for the purpose of reserving any post for persons with disabilities. In the opinion of this court, a reading of section 32 and 33 of the Act of 1995 though provides that the appropriate government is required to identify the posts which can be reserved for persons with disability, and thereupon to carry out the reservation of the post, but not carrying out this exercise at the first instance results in an unfair treatment to the persons with disability who have been conferred rights in terms with the Act of 1995. This court duly takes note of that one post in the district judiciary, in the subordinate judiciary of the district of the Kamrup district, Kamrup Metro district, is still vacant in view of the pendency of the present proceedings. One post still vacant. MACP form. there was a requirement for the Gauhati High Court exercising powers under Article 235 of the Constitution to identify the said post. The same having not been carried out prior to the advertisement. This court directs the respondent authorities to fill up the said post. By carrying out an exercise to identify the post wherein a reserved category candidate with disability can be accommodated. Accordingly, the writ petition therefore stands disposed of with the following objection or observations and directions. The one post which is still vacant in this Kamrup district and the number one. This court is not inclined to set aside the advertisement, taking into account that persons have been appointed on the basis of this advertisement and their rights and have been duly appointed pursuant to the advertisements and have been rendering service for the last 9 years. Yes. Pursuant to a proper selection process. Number two. As regards the one post vacant which is in the district judiciary, in the subordinate judiciary of the district of the Kamrup Metro District, the respondent number 2 and 3 are directed to identify a post in the Kamrup District Judiciary, in the Kamrup Metro subordinate judiciary, in the subordinate judiciary of the Kamrup Metro, where a person with disability can be accommodated. Upon identifying the said post be advertised and filled up in accordance with law. This court duly takes note of that the petitioner was 34 years as on the date of filing of the instant writ petition. As on date, the petitioner would be around 46 years, isn't it? 46? 43. At the time he was 34, at the time 43. Be around 43. Considering the above, this court observes that in the circumstance there is a requirement for age relaxation for filling up of the post pursuant to an advertisement. The petitioner may be granted the age relaxation if so required. Yes. What was the other matter earlier? They were asked for something, they were fighting. affidavit file.
Yes, yes, ma'am.
In the ground in the affidavit.
What is the affidavit of the respondent? I quote.
But we have filed on 14 file. At page 36.
Yes, tell me, yes, Mr. Why was he reverted back?
My lord, kindly come to annexure B page 24 of the DPP.
Letter
B,
of the writ petition.
my lord. This is the order number 31 dated 3/3/2022. Here, my lord, at serial number 3, Iftikhar Azad, serial number 4, Arif Ahmed,
Supervisory assistant promoted upgraded to the existing vacant post of civil solicitor. Office of the Munsif number 1 to be in the usual pay band of rupees so and so carrying the identical by so and so. Then the petitioner comes. Upper division officer of the year is promoted to the civil solicitor, both same of the Munsif. Bilasipara in the usual pay. Okay, then
and number 5 is the so and so UDA, office of the undersigned is promoted to the post of supervisory assistant SA in the as usual pay band rupees so and so so and so. Now, my lord, what happened, my lord?
so he goes to the post of supervisory assistant, which was held by Arif Ahmed.
My lord,
Or
now
Arif
what
Tigarada
happened?
of this one.
My lord, what happened, my lord? The appointment of Iftikhar Azad, who is at serial number 3, was challenged, and I have annexed the order of this honorable court, which is annexure 1.
It is Omar Chakraborty.
My lord, here, my lord, respondent number 6 is that person, Iftikhar Azad.
Who is challenging? Omar Chakraborty is
You as another candidate for that post, my lord.
he post was challenged on the ground of ER. The establishment of ER duly being permitted by ER 31(3)(31). Okay, then
Then kindly come to paragraph 14, my lord. Before parting with the records, the court also finds it more pertinent to take note of the submission made by Mr. SCB learned counsel appearing for the respondent number 6 to the effect that one Arif Ahmed, who was junior to the respondent number 6, had been promoted to the post of civil solicitor in the office of Munshi Bilasipara. This court has duly taken note of the selection which was carried out in respect of said Arif Ahmed, and from the annexure 8 of the affidavit filed by the respondent number 5, it reveals that the same was a separate selection proceeding which was held on 17/2/2022. 15. The respondent number 6 is so aggrieved by the promotion of Sri Arif Ahmed to the post of civil solicitor in the office of Munshi Bilasipara would be at liberty to do so if so permissible under the law. Now, my lord, next, my lord, again kindly come to that order 31. That is serial number 5. Sunilam Dev Chaudhary. His selection was also checked. And that was also interfered, my lord. It's one of the- Who does the- Here, my lord,
Now, but this Suliram Adhikari was promoted from to the
UDA,
post of Arifamen.
yes, that is later on.
It's okay, but
My-
Suliram Dev Adhikari was promoted to the post of Arifamen. Or
Arif-
Iftikar. Iftikar.
No, my lord.
Yes, kindly see.
Yes, ma'am.
Yes, he was promoted to the post of Suliram Dev Adhikari as Iftikar Azad.
Ma'am.
So Iftikar Azad, I have already interfered in another case.
My lord.
Amar Chakraborty case. Now here, Kamini Kumar Das challenges, who is Kamini Kumar Das again, he is not here. Okay. So he is challenging the promotion of
Sunilam Dev Adhikari.
Then what happened?
Here, my lord, paragraph 23, that selection was interfered with, and as there was no minimum benchmark.
Part with the increase of the detection by which was I. Okay. The respondent number 6 to the post of and pick the interface unity position of the commissioner. Know the respondent 6. I think the part of the impugn order dated so and so is set aside at court. With the setting aside and quashing of the impugn order dated in writing, incumbent on the part of the employer to revisit the matter of promotion to the post of supervisory assistant. It is observed that in the event of the employer prior to undertaking the exercise of promotion to the post of supervisor, and fix the minimum benchmark for accessibility and then the employer shall revisit. If there is no prefix so and so, so and so, so and so. But here also they don't touch Arifamen.
My lord, then what happened, my lord? Both 3 and 5, the court interfered with, and this sticker Azad, he filed a recruitment before the authority. And the authority thought that, yes, in selection of Arif Ahmed also, we have not fixed the minimum benchmark. And when
So you cancel the promotion without interfering. Who are you?
his private estate, Sunilam.
He has been promoted there.
He has been promoted later on. FCS selection was after 2 years, and in that selection process, minimum benchmark was set, and he could not qualify the minimum benchmark. He participated, he could not qualify the minimum benchmark. He is the junior to the repetitioner, but he scored more than minimum qualification. That's why he was selected.
So when was this, when did this happen? And you have gone to the extent of asking for recovery from him also. Yes. Unless somebody don't challenge it, yeah, how can you do it by yourself?
Minor. Very true.
Possible.
Minor. They thought that it will be justified because 3 and 5, both their selections were interfered with. So upon a representation they acted.
Paragraph 7 of the procedures order. Okay.
Relevant minutes is at annexure 2, my lord, of my affidavit in opposition at page 62.
So they were appointed as LDA on the same day. Iftikhar, Arif and Sulina, same day.
Same. Lord.
But UDA, Iftikhar is on 1/4/2015. Arif is on 1/9/2015. And Suliram is on 1/9/2015. Both are same. Now, thereupon, you became heir on 25/2024. But one case will have, that entire selection has to go through that post. Other selection of it, which is also challenging. We need not challenge it. Why should we go to the second one? It becomes honest. But he became a civil solicitor in there.
In the fresh advertisement, which where he also participated. I also participated. I got selected. He did not qualify in the minimum
post of
benchmark.
head assistant.
Head assistant.
No, head assistant, we are not concerned.
So he's challenging that. So if
Why?
page 146 madam, of my affidavit.
Head assistant.
Head assistant. This is a different promotional exercise where I participated. He also participated. But there he could not fulfill the minimum benchmark.
That is okay. That I'm not going to touch.
And for
That
that
you
matter, I
becoming
qualified.
there, it's okay. But he could not have been brought down from
Yes.
civil solicitor to what we call
Yes.
the other one.
Yes.
You have been brought down to where? UTA, that is not permissible.
Right.
Hello, we'll pass that order. He becomes the civil solicitor. And I'm not touching on your selection because otherwise also you are qualified as a supervisory assistant. He was there as a supervisory assistant. So he gets it. So I'm not touching on him, on that selection. But I'm only touching on him being brought from civil solicitor back to you.
It was synergy of merit manner.
Huh?
It was synergy of merit as per the rules.
But they have fixed the benchmark.
Yes.
What case do you have? What case do you have as regards the promotion of him to head assistant?
No, my case is in the matter, I was promoted by selection. In selection in 2022. To the post of second civil solicitor. And in 2024, after 2 years, suddenly I was reverted.
That's okay.
That's why.
But you have been permitted to participate in the selection. That is okay. So you have participated. Now, if there was a problem on the question of seniority, you having crossed the minimum benchmark and got the seniority, the question would have been different. Then your seniority would have come into the because you were a civil solicitor on a year. Otherwise, you were also senior to him. I'm saying that. Although appointed, all appointment is on the same. Same. Then what is your case?
By age, I am saying that. Appointment is same day, by age, I am saying that. When the same day is appointment, then age will be the same. Well, my reversal was without notice, without any.
No, that's okay. That is one. You have to mix up many causes of action together. One is where you have been brought down, and the other. Now, have you challenged the reversal?
Reversal,
We have not challenged the reversal, then that also. I have come out here and said all these things. Later on, I come to where is the reversal for the challenge? When was the reversal back?
Minor 23, 424. At page
So you
27.
have annexure C. So you're challenging annexure C.
Yes.
So annexure C is okay, that will do, and as regards the other. So then the question of recovery of him would not arise. Otherwise, you are going to take recovery to one post so many cases, and one person you are challenging. That is the big problem. Earlier, Mr. Vishwas was only challenging one person and then say that the phone number 6, the fellow person, that person is there. Therefore, I granted him the lead. He did not challenge.
It become very already a lawsuit knows more that the 2023 judgment of Supreme Court. Paragraph 91 and 94. Correct.
What is that?
The Senate will count the day.
Where? In your
Senate of merit.
no quarrel, but if
And
the minimum benchmark is setting, and if the minimum benchmark you don't qualify, then you are out. That's the law.
And that also was not on the Senate committee. If you are not to see the proceeding. But election. It was merit and suitability. Senate didn't consider that now. So
Okay, show me then you want to contest for the merit on that aspect. Let us. What is your? They have filed it and where is the proceeding for here? The selection proceedings.
case 64 electricity countered by the students. Both review assessment further result to set a minimum benchmark for assessing India's merit suitability.
When did you fix the minimum benchmark? When did you pick the minimum benchmark of 35?
On the 23rd October 2024.
Huh?
23rd October 2024.
How do you know?
Whereas it is page 64 madam. In the proceeding and selection report proceeding.
Regarding the marks for intervention, evaluation of the. Therefore, a minimum benchmark of 7. Will be. Wait. And Viva will say will be 12. Viva will say will be 12.
I think it's not so percent. To total aggregate assessment, CR assessment.
When was the interview held? You were very less in Viva Voce. That actually changed everything, huh? Okay. One after the second, consecutively. And where your marks pertaining to this? How did you arrive at 7.67 amongst the three? And the record is with me. Show me the record. 7.67 is very difficult to find. Nine. Where is that? That I got it page number one. In the record. It was done in 2022, huh? 24. And when did he file the petition? 24 inches. Mr. Sharma, you don't have it for the. Have good people. They have done it. We can't go so deep into it. The Supreme Court has categorically barred going into so deep. Here we have, they have fixed for writing 2012 for Viva Voce and 2018 and how much 18 is for this year. Okay. Partly. Yeah, give me the what is it? That money. Which one? I think Ravi Kumar. There are 931 and 92. Huh? 91. 93. 0.1 margin. 98. That I know. So, give me a copy. So your
Inversion is the pair with, next the C is the pair with, but your thing is not. Really.
Both of them and
Master. C with.
DPO. The record, take that, go.
Yes, again, your senior is not there.
Here is.
Yes, Mr. Chaudhary, what is your matter about?
Next time.
Okay, let us take your matter. He's not there. Yes.
So there are two repetition. Look, item number 3998. This is item number 6. Here, my lord, our there is or reconstitution of the leadership. What had happened?
Yes.
My lord, initially, petitioner number 2's husband was operating this petrol pump in Aizawl town, my lord, as a proprietorship business. Now, my lord, he died. He died on 30th of January 2018. After his death, my
30th
lord,
of January,
yes, 30118.
in Sing-Song service station
Yes,
was in the, was.
was a proprietorship, my lord.
30th of January,
The Ronald Singson, husband of the petitioner number 2, died.
31, 2000.
300118.
Ronald Simpson died.
Died. After his death, my lord, the petitioner number 2 and her brother-in-law, that means brother of Ronald Singson, my lord, they formed a partnership and they were operating. His name is, my lord, Dennis.
So now it has become MS Sing-Song.
No, that is, yeah, no,
That's the partnership.
that's the name of the petrol pump. Messrs. Singson Service Station is the name. Under business trade name, under which the business is taken. Now, not coincidentally, Dennis also died on 13/3/23.
13/3/26.
23. 13th of March 23. Now, my lord, for some time after the death of Dennis, the dealership was run by petitioner number 2, that is the wife of Ronald Miller. And a reconstitution aspect was pending with the SPCM. Now, ideally, our prayer is, my lord, they should reconstitute the dealership as a proprietorship, constituting only of petitioner number 2. So that is what is prayed for in this case. Now, in the other writ petition, the issue is, my lord,
Before going there,
yes,
now Ronald Simpson died, and pursuant to that, his wife comes in along with his
brother,
Ronald Simpson's brother. Now, whether this reconstitution was permitted by IOCL,
yes, that was part.
so that was permitted. So now he has died. The moment he died, the partnership was dissolved.
Dissolved, naturally, my lord, one to one part
By
of the
law, it is
section 40.
dissolved unless the legal representatives may
Is
have a
brought in.
claim. Where if the partnership firm terms and conditions mentions that how the in that case, sometimes it remains where the legal representative person will be brought.
We have annexed a judgment of the Honorable Supreme Court interpreting section 42. Supreme Court says the moment in a case of where there are two partnerships, one of the partner dies, then it stands different.
That is true.
Yes.
There's no quarrel with that proposition, but the fact that if by the partnership deed, it is being survived, because if you
Of course,
see,
if
you
there
see
is
the
any
Partnership
provision,
Act,
yes.
everywhere it is mentioned, unless the parties otherwise mention, this is the, this is how the partnership works. All sections of partnership.
The Lordship may kindly come to page 34, where annex the order of the Supreme Court. Lord, please come to page 33, paragraph 27 towards the bottom of the page. Page 33. In order to arrive at the conclusion that partnership firms should dissolve on account of death of one of the partners, the High Court had rightly placed reliance on so and so, wherein the High Court held that in a firm consisting of two partners, on account of death of one of the partners, the firm automatically is dissolved, and the observation is as follows. Partnership normally dissolves on the date of a partner unless there was an agreement to the contrary. There was no such agreement in the original partnership deed. Even assuming there was such an agreement in a partnership consisting of two partners, on the death of one of them, the partnership automatically comes to an end. There is no partnership which survives and into which a third party can be introduced. Hence, on the death of S, the original partnership was dissolved. The subsequent taking in of the SSC as a partner was only as a result of entering into a new partnership between R and the SSC. The partnership was not a matter of heritable status, but purely one of contract. In the light of the aforementioned case, it is clear that when there are only two partners constituting the partnership firm, on the death of one of them, the firm is deemed to be dissolved despite the existence of a clause which says otherwise. A partnership is a contract between the partners. There cannot be any contract unilaterally without acceptance by the other party.
But if you kindly come to 33.
Yes,
Page 33, how they have constituted 32.
yes,
Subject to the contract between the partners, a
Yes.
firm is dissolved
yes.
by the death of a partner. Therefore,
Normally,
if it is
Normally
being
what your
continued
lordship
and
says
say that,
is
okay,
yes.
if legal representative will come in, it shall remain. That is why you find that this position of law. Therefore, you see a partnership normally dissolves on the death of a partner, unless there is an agreement to the contrary.
no, that is the position, but my lord, by going by the Supreme Court's observation.
Anyway, that'll help you.
Anyway, so my lord, our case is, it should be reconstituted, my lord. Now, that is not the bigger issue. The bigger issue is in the other writ petition. The other writ petition, the issue is, my lord, the partner, this dealership petrol pump, my lord.
No, the partnership, now the question is, once it is dissolved,
Yes,
then the
Unless
assets will
that-
go back to there is a effect of dissolution.
as if there is no partnership.
There is no authority, but what happens to the assets?
Yes. No, assets will be lot, that will be taken care of.
No, that is the main thing with the, what will happen to the assets of the firm?
One survives. The petitioner number 2 survives. Therefore, she will succeed.
Can she succeed for the entire thing? She cannot, because otherwise the law of succession will hit him.
Here, if we go by the reconstitution rules of the oil company, these are very liberal.
It's okay.
Their only anxiety is, no, unless the other party comes and claims that's a different issue. That is not the issue in this proceeding. In these two proceedings, first issue is regarding reconstitution, and in the second, lot of repairs are to be done. For example, construction of retaining wall and all. Who will do because there is the landslide, the portion has been swept away. So now, under the oil company's guideline, it is the oil company who has to. In case
the dealership is owned by scheduled tribe. Now, whereas in this case, my lord, the oil company has taken a stand that they will do it, but they will reimburse the money from us. That is what is challenged in the other case. So once the my lord, main issue is resolved, I think reconstitution may not be that big. Now, if your lordship should kindly come to the other writ petition, my lord. Now, what has been challenged is, my lord, page number 82. Now, the oil company is also treating the petitioner number 2 as the person concerned. Communication regarding construction of boundary wall, retaining wall and land development. With respect to the letter from the office of the Deputy Commissioner Aizol, dated 23rd of December 24, it was instructed that the design and construction of the entire retaining wall to be done by the Hindustan Petroleum Corporation. The drawing plans, cost estimate and construction of retaining wall has to be done by HPCL. As per the prevailing policy of HPCL and dealer selection guideline of enforcement, construction of boundary wall, retaining wall and land development has to be done by dealer. HPCL has already prepared the design drawing estimate and submitted to the office of BC Aizol for approval of the same. The estimates prepared comes to about 2.97 crore, that is including construction of retaining wall, restoration of facilities, etc. of the outlay. As per the investment policy of the HPCL, recovery of investment from dealer may be done through one of the following options. Option 1, payment of rupees 2.6 lakhs per month by dealer for a period of 20 years. 2, recovery at the rate of 0.75 paisa per liter of MS and HSD sold for 20 years in addition to SSLM. So other than repaying them, nothing will be left. Now, my lord, as against this stand of the my lord, oil company, if your lordships kindly comes to page number 83, that is the selection of dealers, my lord, brochure. Now, please come to page 85. Now, this is introduction, salient features of the selection guidelines, sir. Please come to Roman 5. Corpus Fund Scheme of providing financial assistance.
Why we are concerned with the 2023? Because he must have been, King Song was died in 2018. It must have been given prior to that.
Which one, Miller? Petrol pump is of 2004-5.
So at that point of time, what was the law? What was the terms? Because these are terms. You have to see those terms of 2004-5.
Agreement speaks when everything. The agreement which was executed between the partner speaks everything. The serving partner and the living partner sell the company.
No, Miller.
There's a clause in the agreement.
Because we can rely on this, because these are brochures, these are for selection, these are conditions for NIT and all these things. You can't change it now. This is only for those persons. Guidelines for selection of the dealers for regular, this has come in 2023.
I understand, Miller.
This
have
will
not
come in
undergone
later
change.
on.
But in case of only scheduled tribe, this provision is there. Please permit me to read it, Miller. Corpus Fund Scheme of providing financial assistance by OMC can be availed by applicants applying for location reserved for SC/ST category upon appointment as a dealer. Now, please come to reservation. The percentage of reservation for various categories in all the states except Arunachal Pradesh, Meghalaya, Nagaland, and Mizoram are as under. Please skip over to the next page, Miller. Now, reservation in the state of Arunachal Pradesh, Meghalaya, Nagaland, and Mizoram would be as under. 90% would be for Milord ST and 10% of the retail outlet would be for balance. Then kindly come to 3. Types of sites will be decided by oil companies and same would be location under corpus fund scheme. The offered land would be taken on lease, purchase, and fully developed as corporation's own site. Kindly come to the note, my lord. All locations advertised as SC/ST category will be
Now,
developed.
did you apply for? No, did you apply?
Yes.
First fund scheme of providing financial aid by OMC can be availed by the applicant.
Yes.
Did you apply for that?
This is applicable to SC/ST.
I'm asking you, did you apply when you took it?
Actually, my lord, since there is a provision,
Because obviously this provision came in 2023.
the chair which was obtaining as on that day, that we can procure. There is no
That
difficulty.
is your case. If you have that case, otherwise you cannot.
Yes, yes. And
Without
if,
that, you.
and if Lordship would kindly come to
we
87, my lord.
cannot go by 2023. Very difficult.
We'll have that, my lord. We'll file an additional affidavit, bring on record.
But the petitioner has to clarify, madam, where from they got the page 87 and 88, madam.
Huh?
Page 87 and 88, madam. Is not a part of the Bhushan book. 87 and 88, madam. In the affidavit, madam, we deny these pages, madam, part of.
87 and 88.
This is not a part of my 2023 Bhushan. And 88.
Can't be because 5-6 is not there.
Yes,
huh?
ma'am.
There's something wrong.
No. And I have annexed the Bhushan, madam. In our affidavit opposition, madam, you can start from, madam, 184 to 209.
This is available in your website.
I have annexed it.
No, I think what has happened is this. Wait. That is enclosed, he must be, I think they are 87 and 88 in some other guidelines.
Yes, ma'am.
This is for HP. You are HP. This is for some other year maybe. Because this is
OMC, madam.
again different.
IOCL, madam, BPCL and SPCL.
My HP also, my lord.
SP also.
Well, this is for HP. So therefore, you see, you have marked as 8B. So 8A is different and 8B is different, I suppose. To show that they have a practice for doing it. But this 8B is from which period, nobody knows.
Yes.
Now that we'll find out, my lord.
Because that ends there from 88 again will be different.
Yes.
Mr. Chaudhary, I don't think you are doing it properly. Finally, see 87. Yes, it starts with paragraph 7, clause 7.
Yes.
Finally come to page 88. You show it to be a part of it and it starts again with 7.
No, spouse as co-owner.
No, I'm saying, you see, 87 is page clause 7. On,
Since it was not given relevant matters, or maybe it was not given.
no, I'm saying it. 87 is clause 7 on top.
So the Lordship will kindly come towards the bottom, 4 and 6 and 9.
No. Kindly come to page 87, annexure 8B.
Yes.
On top, on the left
Para
is
7,
clause 7. Then you come to 88.
again 7.
Again 7. So this is again another document, somewhere, some other document.
And my lord will sort it out.
Heard Mr. K. Chaudhary, the learned senior counsel assisted by so appearing on behalf of the petitioner. In both the petition, Mr. S. Thakur appears for the Hindustan Paper Petroleum Corporation Limited, HPCL.
Yes.
SS Roy appears for the Union of India. So appears for the state of Mizoram. We state it as you may not be 4 and 5 in the other
or both 4 and 5? Right, so we therefore put it as additional advocate general appearing for the state of Missouri. You are so and so appears for the private respondent. Who are you? Why is the private respondent here?
The petitioner, before coming to court, my lord, has submitted a reconsideration form, my lord.
Huh?
He applied for reconsideration, my lord.
Then
My lord, before coming to the court, my lord, he submitted an online application for a C, my lord. Applied for reconsideration, my lord, along with the private respondent, my lord.
who is private respondent?
The
Wife
wife of the
Dennis.
Dennis Singh, my lord.
You are. So you are supporting the case of the beach.
There is a clash between the, that's why, my lord,
So we have to make.
both applied, my lord, it is pending
My lord, we
in
have
our
made
office, my lord.
party.
Therefore, he is appearing as a party. So he appears for the private respondent. Both the writ petition raises, though interconnected, raises different issues. WPC number 1863 of 2025 pertains to a challenge being made to a communication issued by the Hindustan by the HPCL. Where is the document? It's already where is the document that you have to pay that amount they will discuss.
Page, my lord, yes. Page number, the
yeah.
other repetition.
Challenging the order dated the communication dated 3/3/2025,
Yes.
whereby the petitioner number 2 have been asked by the chief regional manager HPCL to either carry out the construction of the retaining wall and the restoration facilities, or the HPCL shall carry out the same at a cost of 2.97 crores and recover the same from the petitioner number 2, either by way of payment of deducting, either by payment of rupees 2.60 lakhs per month by the petitioner number 2 for a period of 20 years, or recovery being made of rupees of 0.75 paisa per liter of MS and HSD sold for 20 years in addition to SSLF. It is the case of the writ petitioner that taking into account that the writ petitioner, taking into account that the petitioner number 2 is a scheduled tribe. The HPCL has to incur such cost on its own without burdening the petitioner number 2. In that regard, Mr. K. N. Chaudhary, the learned senior counsel, have referred to the brochure of selection of dealers for regular and rural retail outlets of June 2023, and specifically referred to the guidelines of
on selection of dealers for regular and rural retail outlets through draw of lots of the bidding process, and to the corpus fund scheme. This court duly inquired with Mr. Kane Chaudhary, the learned senior counsel, as to how the brochure for selection of dealers for regular and rural retail outlet June 2023 can be applicable, taking into account that the petrol pump in which the petrol retail outlet was set up sometime in the year 2004-5, and the relevant proceedings and relevant terms of the contract has to be seen from the brochure of select. Is as per the agreed terms and conditions. And as such, the petitioner cannot claim such benefits. Mr. Kane Chaudhary, the learned senior counsel, submitted that he would place the necessary materials by way of additional affidavit in this regard. Other writ petition, the second writ petition, relates to constitution. Relates to the inaction on the part of the HPCL in permitting the reconstitution of the firm. Inasmuch as the firm, namely MS, the firm, namely MS Simpson Service Station, was initially a proprietorship firm of the husband of the petitioner number 2, and thereupon, after his death on 31/2018, it was converted into a partnership firm between the petitioner number 2 and one Daniel Singson. Dennis Singson. The said Dennis Singson expired on 13/3/2023, and it is the contention of the learned senior counsel appearing on behalf of the petitioner that the partnership firm automatically stood dissolved by operation of law, and accordingly referred to the judgment of the Supreme Court in the case of Muhammad Laiuddin and another versus Kamala Devi Mishra, bracket dead by LRs and others, reported in 2010 2 SCC 407. The learned counsel therefore senior counsel therefore submitted that on one hand, the respondent authorities, respondent HPCL duly recognizes the petitioner number 2 and have issued the communication dated 3/3/2025. And on the other hand, the said firm, the said trade name, Sing-Song Service Station, is not being reconstituted. And therefore, the present petition is being filed. So considering the fact that there would be an affidavit, there will be, considering the fact that Mr. Kane Chaudhary, the learned senior counsel, has submitted that an additional affidavit would be filed. This court directs the listing of this matter again on 21st of July 2026. If in the meantime, the additional yes.
Matter has become infructuous, you know.
What?
This matter has become infructuous.
Why? You have withdrawn.
No, the issue of subsequently, my lord, the WLR reports are quarterly, my lord, issued. In the subsequent WLR report, my lord, he has not been put in the negative list. So automatically it's superseded.
Where? Anything you have? Yes, it is on report. See, Mr. Saika, it made sense. It made sense to wait for him.
These are for April and May, my lord. He's not been put in negative list.
Although heard Mr. K.J. Saikya, the learned counsel, appearing on behalf of the petitioner. Mr. H. Gupta, the learned CGC, appears on behalf of the respondent numbers 1 to 7. The petitioner in the present petition have assailed the order dated 31/7/2025 as well as the order dated 15/10/2025, whereby the petitioners have been put in a negative list, that too without following the mandate of the principles of natural justice and more particularly the proviso to clause 23.1 bracket Roman 6 of the bid document, which categorically stipulates not only that there should be a notice giving 15 days to the person against whom actions are contemplated to put in the negative list, but there's also a requirement of passing an order. Mr. H. Gupta, the learned CGC, submits that the instant writ petition has become infructuous, that in as much as these orders which are being passed are based upon quarterly review. Pursuant to the order dated 15/10/2025 and the quarterly review done, the petitioner is no longer in the negative list. In that regard, he has referred to the communication.
In April 26.
Communication dated 15th April 2026. And the enclosure thereto as regards the enlisted contractors and unenlisted contractors. In the same enclosure, it is shown that the petitioner name is at serial number 15. And in the column, inverted comma, whether considered capable of handling more load, it is mentioned as yes. In addition to that, in the remarks oblique reasons mentioned, it is remarks oblique reasons, it is column, it is mentioned as work under progress.
Mr. H. Gupta further have referred to another communication dated 11th of May 2026. You are what? PR.
Tenor, tenor engineering. First tenor.
On the second last page, we wrote serial number 156. Wherein also, in the workload return for quarter ending March 2026, the petitioner has been shown at serial number 156. And in the column as to whether considered capable of handling more load as approved by the DGBR, it is shown the remark being, yes. In addition to that, there is no remark being put against the petitioner. These communications which have been placed before this court are kept on record and marked with the letter X and Y. In view of the above, comma, as the petitioner is no longer in the negative list, there is nothing, nothing further remains to be decided in the instant petition. Accordingly, the writ petition stands closed. And what do you say about did you issue a notice as for 23?
Regarding the,
Any order did you pass? No. So therefore, we hold that those negative lists shall not be considered in future. Because otherwise there will be a big problem now. That will be, sometime will come.
there was another writ petition filed, wherein they were not debarred from participating. So pursuant to withdrawal of our orders, he was allowed to participate.
Okay.
That writ petition was allowed to participate in the kind.
What is this? Such a small petition in the matter. What is
Some bill,
Huh?
non-payment of some bill, 12 lakhs.
What? Non-payment of a bill on Tuesday, Thursday?
This is exception, madam. We have forwarded the data in the department. Or in the fund, madam. Women political parties do not have a bill. They have already forwarded in 2024.
You make the home department a party? Really? I am doing it. Really? The Tuesday now, Thursday is here. The petitioner herein is aggrieved by the actions or inaction on the part of the respondent authorities in not releasing the amount of rupees 12,03,473, which the petitioner claims to be entitled for supply of diesel to the CRPF during 2022. The record reveals that this court had issued notice on 13/5/2025
Today, Mr. MCP, appearing on behalf of the District Commissioner Kokrajar, submitted that upon verification being carried out, various bills have been sent to the Home and Political Department, Government of Assam, for making payment by the District Commissioner Kokrajar as on 18/7/2024. And on account of non-payment of the said amount, the petitioner have not been paid. Considering the above, it is the opinion of this court that the Home and Political Department of the Government of Assam ought to be made a party in the instant proceedings. Accordingly, this court impledes the Commissioner and Secretary, Additional Chief Secretary, what?
Joint Secretary.
Huh?
This letter was sent to Joint Secretary.
No. Home and Political Department, who appear? You appear, but you don't know who is your boss. Who's the boss of government? Commissioner and Secretary or Additional Chief Secretary? Huh? Commissioner and Secretary. The Commissioner and Secretary, Government of Assam, Home and Political Department is having his office at Dispur, Gauhati 781006 is included as the respondent number 4 to the instant proceedings. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 3 days, and the registry thereupon shall make necessary changes in the cause title and update the same in the CIS. Next. The learned counsel appearing on Mr. MCK, the learned counsel who appears on behalf of the respondent number 2 and 3, further submits that he can accept notice on behalf of the respondent newly impleaded respondent number 4. A copy of the said writ petition be served upon him by within 3 days. List this matter again on and absolutely issue notice upon the newly impleaded respondent number 4, making it returnable on 17th of August 2026. He accepts notice so and so. The respondent numbers 2, 3, and 4 are directed to bring on record their stand by filing the affidavits on or before 12th of August 2025.
This case for a response to when he filed affidavit. We have already filed reply also.
And what is required?
What
What is code?
regulation?
What?
Regulation of service of full permit. Petitioner is working.
Very difficult. We can't allow this regularization. It cannot be. This goes against the government. There is another matter of Mr. Yes, there is one matter now of regularization of people. Remember that matter? Huh? There is another matter. We take this along with it because they have challenged that notification of the government. When the government says that except in health department there will be. Anyway, you don't need to challenge because he has already been challenging. We take this matter. Get the number. Is this matter along with that matter on that? I must have fixed the date in that. Just find out.
Picking the challenge
Now, what
the
do you
promotion
want
of the
here?
private respondent to the post of process server in MSC Nagaon. Now, they have, the High Court has filed their affidavit, my lord. What they have said, my premium contention was that seniority cum merit was not followed. Seniority cum merit, why? Because the gradation list which was prepared before the promotion exercise, that gradation list was not prepared as per the constitution. They said that the gradation list was prepared as per the merit in the common recruitment drive. But it was a combined recruitment drive, not a common recruitment drive for the post of grade 2. So that gradation list being bad, the subsequent promotion exercise from seniority cum merit, their license challenge. Praying to find an entire method, I've been instructed.
So you say, that's one number 5 and 6 should be placed below me in the gradation list. One number 5 has been put.
5 has been selected, madam. And 6 also, he got more marks in the merit position. So what I'm saying is I'm senior to 5 and 6 both. So being senior, the
This is the promotion from where to where?
from grade 4 to process 7.
It's seniority cum merit.
They admit so in the affidavit. They admit so in the affidavit. It's there in the statement.
How?
But in the affidavit,
This is in which place?
MSCT Nogam.
How is the MSCT Nagaon Assam, the district rules will apply?
They follow,
How? Yeah, how can you apply a rule to basically? Unless
Unless
the,
it's
the,
the-
High Court, the 235 direct. This will be followed.
since the MSCT establishment, they don't have their own, since the MSCT establishment, they don't have their own rules, so they follow the
How can they,
ministerial service rules.
that is a big problem, no? This is a big issue. How will they follow? Somewhere, something comes in somewhere. Something has to be there. The problem with this case, you are the main source of trouble of Mr. H.K. Das. That case of industrial tribunal also same problem.
Yes.
They applied the CGM establishment rules. CGM establishment rules,
Yes.
they were calling from all the judiciary. When you appoint the registrar or something to the effect or something in the CGM, normally in the district judiciary, in the district courts, it is intra-court.
Yes.
But if it is CGM, you call for everybody, because that is one establishment, na? I think most probably there's less offices also, we call for various other places.
Yes.
So there he applied, that was done for the purpose of that. Now, why there is no uniformity? What is the basis of you following either the CDM rules or the district administration? That is established. There's a requirement also having some executive instruction on this by the High Court.
There was some decision taken by the Honorable Chief Justice long back regarding applicability of this rule.
Honorable Chief Justice have no power.
No, it's by the rule committee.
Rule committee also doesn't have power. It has to be taken by the High Court because it is 235.
Yes. I just go through it, one of the matters is that this, I think.
If you see the judgment, there's an interesting judgment on the point of that I think will be good. Where, what has happened, a question arose at one point of time as to whether the Chief Justice could transfer cherish the of from one district to the other. This muching is of very big relevance because whether the chief justice will lead the high court under 235, because the high court is defined. Chief justice role is for the only the high court. Chief justice may say anything against the ministry. He has all the power. High court has no power. But when it comes to the subordinate judiciary, it is the high court. It is a very important issue. But in that case, the full court has empowered the chief justice to look into the question of vigilance. And because of that, if this person was having some problem with the vigilance, some complaint was given, he had the power. That is what the Supreme Court held. That is in 1990. Otherwise, chief justice has no power. So chief justice is saying that these rules will apply, that will go.
But I can get this clarification. I haven't gone through it.
Because unless, because that is a big problem.
Some decision is
We
there at
need
the level of high.
clarity on this. Yes, that they may very well say that kindly apply these rules for this. Because these posts are not cadre posts within the judiciary rules.
No.
The nomenclature of the post may remain the same.
But the selections are made
It
that
may be
in
done,
that
something
category.
may be done. They
Yeah.
have to adopt somewhere.
Yes, some
Because
adoption.
that is why the problem arises with this. They come within the ambit of the subordinate judiciary. There's no quarrel with them.
Correct.
In view of various reasons. They come. Now, if they come in, they will be controlled. But how do you control them by way of a regulation rules? Unless somewhere says that these rules will apply. These rules-
There has to be some considered decision somewhere that this rule is. Yes, so true. That's true.
Is the cause of being.
But here, my lord, he is relying on a seniority list, which was erroneously prepared. And
No,
that-
but it's okay. Erroneously prepared,
it was corrected later on.
now see, the promotion was made on what basis?
As per the minutes, seniority come merit.
Senior income merit.
So he was not senior. He was not senior.
He was not senior.
Not senior.
Because
Because
the gradation.
earlier senior, my lord, what happens? My lord, the gradation list which was prepared, it was not on the basis of merit. There was a notification by the High Court saying that at the time of, if the initial appointment was based on selection and merit list is prepared, the seniority has to be determined by virtue of their merit position. So lordship's judgment is also there, one of the judgments.
Others may go on.
So there is one judgment of,
What my other friend is repeatedly saying is that it's a common recruitment drive. What I am saying, it's a combined recruitment drive. They advertise process server, night and day chowkidar, office peon and peon for officer. One advertisement covers everyone. Written test, written test help. Why? Because of administrative convenience. And once the results are declared, there are separate merit lists. Appointment given separately. So many people applies for all the separate posts. In the advertisement, it is stated that only one candidate can apply for only one post. But later on, what they do, they club everything together, taking the marks of the ones who have been given appointments, and then they prepare one particular gradation list. It's not a common recruitment drive, it's a combined recruitment drive. There, what I want to speak with Madam, and that's why I wanted to.
Because when there are various posts belonging to different cadres, that is again a big issue. What is happening in many cases that I could see, various posts are being filled up. Just for example, in one of the letters today, 1995, that thing, they are saying about MSc. MSCG, they have identified this post as from MSc. But how do you, if you can identify the post to MSCG, you know that You could identify the post to MSP. Why you could not identify the post to the requirement of a PWD? I could finish it. So therefore, I also see that there are a lot of appointments which are being made together. And after that, there's promotions are there. It is on the basis of the recommendation, the postings are being given. You may have landed out there in MSc. Some may have landed out there in MSc. Somebody may have landed out in respect to the same post. May have landed out there in Nagaon district division or Kamrupur district division. This is how the landing happened. And thereupon, the appointment orders are being passed. So your therefore submission is, it is a case of, it cannot be a case, it's not a case of combined.
It's a case of combined, not
Combined, not common. Because these are different, having different cadres.
They advertise process server along
In fact, this is a
These are all grateful posts, my lord. These are
That's one day this is going to cause some problem somewhere. And in
Post-
fact, I am
postings.
seeing some problems arising in some cases. Just for example, I could see a case problem where you remember those cases pertaining to, I think,
Kamrup.
that the one lady appeared in Mohonto. She was appearing for the High Court. I think it's the-
Yes, okay, yes,
Father was a judge, district judge.
yes, yes,
Know that?
yes, yes.
But this is another case. What has happened? These two persons, three persons were being posted pursuant to this appointment at MSc. Now, when they were sent out there to some MSc out here, these persons, the High Court sent it, referred it out there, appointment orders were being passed. Now, this person concerned was not informed as to he was senior in the select list. He was not informed.
Yeah, I remember two different appointment orders on two different dates on the basis of that
The person who was senior, his appointment order was issued later on.
later on.
And therefore, the moment he got it, joined it. The person junior, his appointment order was issued previously. And therefore, he's getting a senior. I have to interfere. So this is how the main problem is. And this is going to boil down one day. I may not be here, but one day.
stated by your lordship in your lordship judgment of
In
1512. In one particular matter which he has annexed. There also your lordship has given some kind of.
My lord, I
Which
have
order?
annexed, I have annexed your lordship's order, my lord, page 218, R2, similar situation arose in MSCP. There, my lord, two different appointments.
That was regarding joining. He joined a couple of cases later.
But
Oh, yeah,
there your lordship,
this is the no. Oh yes, this is
yes,
the
this is the case.
this is the case.
There your lordship's, because there's the problem, if we don't fix
Yes,
the
you see,
seniority.
kindly come to page 230. You will find out.
Yes, my lord. This
These
was a
three
mistake
persons,
done there.
Pranjit, so and this person. Now, all these persons were, they had a seniority. Appointment provisionally selected. Then the appointment order was subsequently issued to one
On two different
and
dates.
the other,
Yes.
the person
But-
who was senior,
On
his
merit.
appointment, and therefore he was not considered. And therefore I had to interfere. So this is the thing. I don't know.
So ultimately, your lordships, in that case also, your lordships has held that the seniority has to be on the basis of merit.
Merit. The merit seniority has to be.
So whatever description my learned brother calls it a combine or common, whatever, the merit position has to be considered while fixing seniority.
Because so then you can very well apply, there is a rule out there, 10.
Then the notification, yes, 12-1.
12. So that rule categorically mentions that if he joins within 15 days,
Yes.
and even if he shows good reason for another 15 days, it will be as per his list in the senior list.
Correct.
in the select list, and thereupon he loses.
Exactly. So here, my lord, the
Right,
private
again,
respondent,
no, this things doesn't apply in my case. I'm saying that might be true, but that is not my ground. What I'll take that argument. So let's just find a difference.
the respondent number 5, he scored 99.2, petitioner 93.3. So that's why they recasted the seniority list and my lord, corrected it. Thereafter, my lord, the selection was held. And there was benchmark seniority ka merit criteria was followed. That is the whole case.
2024, they prepared edition days.
What is the name of the petitioner?
For
Ritu Bora. Ritu Bora got 39.5. And what was the benchmark? You are saying that it should be seniority cum merit.
seniority come merit.
And if it is seniority cum merit, what was the minimum benchmark? 35.
They all of them qualified.
So if all of them have qualified, then you being senior, you go up. Yes, Mr. B. Gogoi. Oh, you, why haven't you told us? I'm happily discussing with them for future High Court things. What is the matter?
No, that was is a bit complex. What people are
Is it a Monday matter, Tuesday matter? Monday matter.
Yes.
Is it a Monday, Wednesday matter? Okay.
Can be taken up.
Today is Thursday, na? We'll have it on Monday, 2 p.m. Interim order clinic. There will be the interim order. No interim order. Okay, Monday. Yeah, at 2 p.m. Paucity of time will not. Okay, then. So therefore, you are now. How were the appointed? Let us see your appointment order.
The first day advertisement.
Now, where you in the select list?
The minutes of the.
No. First point.
Yes. Page 27. Page 27, this is the resolution where they prepared a merit list of all the posts. There,
You are not there.
at page 29, peon for officer. The first one. Page 29, peon for officer, number 1, G2 Bora. And above your lordship would see office peon, Hironya Ballab Bora, that is the private respondent. The private respondent is Hironya Ballab Bora under office peon at the top of the page. Office peon.
He got 99.2.
He got 99.2, I got 93.3.
So you are lower.
I was lower.
Okay.
I admit it. What I'm saying is that all of these posts, even though they were advertised together, separate merit lists have been prepared. There were separate posts. They can post it. And that's why separate merit lists have been prepared. In the advertisement says that I can apply for only one particular post. That has been done. So
But it's the same post, both. Both are same post.
no,
Do you have a different scale of pay? It's the same post. It is a different thing that one is attached with the office and the other is attached with the officer.
Ultimately, grade 4. Seniority list will have to be prepared by going by the grade 4.
again, here I'll make one distinction, my lord. At page 27, process server was also tagged along with that particular advertisement. So day and night chokidar, process server, and office peon and peon for officer, 5 posts. So process server, no doubt it's a grade 4 post. But the first gradation list which they prepare in 2024, they prepare separate gradation list for process server. And one separate.
The process server is different. You are promoted from peon to process server.
If that being so, my lord, then how come it's a common recruitment?
So, are you challenging your appointment?
Exactly.
Then you challenge it. We consider it a challenge to your appointment. So yes, she appeared in that way. So, So,
Let me find it out, my lord. Let me find a reply.
he has no urgency now. Go ahead. I've actually the appointment.
No, they filed the affidavit 4 days ago, my lord. I'll come up with a reply very soon.
The respondent numbers 1 to 4 have filed their affidavit in opposition on 6/6/2026. The counsel for the petitioner submits that as the affidavit have been filed only 4 days back, he would like to consult with the petitioner as to whether the petitioner would like to file a reply. Considering the above, list this matter on 23rd of July 2026. In the meantime, the petitioner would be at liberty to file their affidavit in reply. That case,
I don't think that's because ultimately the same traditional is prepared date for. So in whatever manner the selection is held,
And also, no, again, if seniority of merit is not allowed, then the entire process should also go.
no, seniority ka merit was allowed. Benchmark 18 was created. I'll show you. 18 was created. Thereafter, seniority basis promotion was given. Not on the basis of mark.
you have no case, otherwise you are junior. You got 39.5. Others have got much more. Yes, that advocate. Yes, info. What has happened?
Yes, my lord, the matter has become infructuous, my lord.
Ah.
The Gauhati High Court has recalled its advertisement and issued a fresh one.
Okay.
But
They have recalled the
Recalled.
advertisement and now they are going for a fresh one.
they have already issued and they have deleted the impugn condition, my lord.
Mr. So-and-so, the petitioner in person, submits that the writ petition has become infructuous in view of the fact that a fresh advertisement has been issued by deleting the earlier impugned clause 2C of the advertisement dated 18/3/2026. Considering the above, the incident writ petition therefore stands closed as infructuous. Okay, only they will extend it.